Every year when you get those tax bills, you're actually just paying the interest on those loans that the bureaucrats put against your deeds. I don't ever tell you about the principles.
So I got a bill from the IRS. We're told what they are. How many of us were told how to operate in that branch of legal tender?
No one.
Everything changed after the 14th Amendment. Everything slowly over decades shifted from common law, free, kind of republic, self-governing nation, reducing everything down into commerce and contracts.
There's a saying that the 13th Amendment freed the slaves, the 14th Amendment enslaved everyone. The Civil Wars were enacted by the banks. It was just a financial thing. The truth of the matter is it just tricked people, everyone, into being slaves in the systems economically.
The state can't create living men and women, so we have this fictional overlay that occurred. The U.S. citizen is essentially an LLC created by the state.
In the public side, the U.S. citizen became the debtor. They became the responsible party for all the debt that the corporate state created. The Constitution has no place in this matter.
We're not victimized by coercion and force. We're victimized by ignorance, by misdirection and obfuscation, but we're not actually victims to the system.
We need the detox from what we've been toxified by in our system. Where the true remedy lies is in...
All right, gentlemen, this has been a long time coming. I'm looking forward to this. Thank you so much for being here.
Yeah, I'm glad to be here. It has been a while.
Grateful to be here. Thank you for having us.
Absolutely. So I'm going to let y'all kind of frame how to begin this because this is a lot to unpack. I guess just start with a brief introduction for each of you of who you are, and then we'll just go from there.
Great. Michael Joseph, the founding director of Sacred Honor Educational Fellowship. And I don't know if you want me to go deeper. I can go into my history. It might take a while.
I mean, I feel like we have like so much to cover in this episode, so probably not, but I'll link that in the show notes for sure.
Yeah, so I founded the fellowship and brought in the Foundation for Self-Governance, which is what we share at the fellowship. And really the most important part, as we were speaking earlier, is breaking the spell, getting people to even understand fundamentally how the system functions through commerce and contracts. And there's a lot of rabbit holes people can go down to learn about this subject matter. And, you know, you can go down the rabbit hole of the Vatican, the London financial system, the Committee of 300, the Anunnaki, the Jesuits, the Zionist. I mean, that's a deep well, and I think it's important for people to study, but we just distilled it down to how the system really controls people through commerce and contracts. And honestly, I think a lot of that stuff can be a great distraction
100%
to getting
agree.
to the truth. So we like to just get down to the fundamentals of how it really functions, and we help people find their way out of it in simple form.
Going down the rabbit hole far enough to where you can still have utility.
Yeah.
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 Makes sense.
Well stated. Yeah.
Mm-hmm. Yeah, and all that's great to wake up and smell the coffee, but we like to focus on solutions and actionable paths forward for ones that move into the private. And with that, I'm Phil Mederi, the equity director at the fellowship. And equity, well, we'll talk more about that later, but it's the form of natural justice that allows us to be left alone to manage our private affairs and without public interference. So I look forward to sharing more of that as we go along, but I'll kick it over to Daniel next.
Thank you. My name is Daniel Menz. I'm the National Status and Passport Director at the Fellowship. And it's all about status correction, but not in the state national or the American national sense. This is just national, and this is a process that has been upheld by the Supreme Court. We'll get into that if you want to. But yeah, I came to the fellowship in 2022, shortly after the Liberties Horizon event that Michael and Shiloh were holding in San Diego. And I've been with them ever since, and it's been a wonderful journey.
It's been a blessing.
Yeah.
So Daniel, you and I were talking off camera before you clicked record, and you were talking about how you got involved in this whole space. And one of the things you brought up is how during 2020 and beyond, you were sort of questioning, how is it that we supposedly live in the most free country in the world, and we've ended up here where people are getting arrested, businesses are being quote unquote forced, and we'll get into how it's not necessarily forced, but are having to shut down, and all this crazy stuff happening despite being in the most free country in the world, supposedly. So I'd love to sort of like begin there. How did we get to where we are now, where those types of things, those types of events are commonplace? Mm-hmm. And people, refer back to their constitutional rights and things like this, and that can have a lot of context that's missing as well. So I just want to sort of frame historically how we got to this point and sort of take it on, I think, a journey chronologically, if that seems appropriate, for how we got to this point.
Yeah, sure. So I'll start with the simple distinction between pre-Civil War America and post-Civil War America, because everything changed after the Civil War, right? And so particularly from the national status perspective, from the status correction perspective, everything changed with the 13th and the 14th Amendment specifically. So Michael is going to go, and Phil also, they're going to go into much more of the detailed history with all this. But that's basically the simple version, right? Because if we look at pre-Civil War America, we had gold-backed currency. You could just walk into any bank and exchange your dollars for gold, no questions asked, right? There were no income taxes. You didn't have to have any permits, no licenses. If you wanted to open a business, maybe there was a little bit of something like that. But if you had a personal private practice of being a healer or being a consultant of some sort, you could freely trade and practice whatever you did without having to pay income tax or any kind of other licenses and whatever. So, and then, of course, everything changed after the 14th Amendment, and then with the Negotiable Instruments Act that came in the late 1800s. And then, so everything slowly over decades shifted from common law, free kind of republic, self-governing nation into completely inverted version of corporate commerce, UCC, basically reducing everything down into commerce and contracts. And so this is why we focus on this particular aspect, because that's really where the rubber meets the road and where we can really most effectively free ourselves.
Got it. Okay. And should we talk about some of the primary moments in which, or that sort of led to us being under this new quote unquote form of government?
I like to usually start out by saying the original organic constitution, and I say organic because there's more than one constitution. There's the organic constitution that's based on principles and it's a trust, and then there's the corporate constitution, which came in the restoration period or reconstruction period after the Civil War. So the original constitution was formulated to limit the legislative powers of government so people could remain in self-governance, right? So it was always designed for us to be the powers and authority of our own life. Right. And we have just the complete opposite of that now. And that's of course what we're talking about, what we want to unpack. So what I'd like to highlight for people is to create a distinction between the language of the 14th Amendment and the language of the original Constitution, 10 amendments, the Bill of Rights. So if you look at the Bill of Rights and you have language that says people and persons. Now persons I think is mentioned once or twice. And in the 14th Amendment, you've got persons, but I don't think they use the word people at all, if I remember correctly.
Nope.
So what's an essential thing to learn is that the law is in the contract. So Article 1, Section 10, Clause 1 states that the state cannot impede or impair upon the obligation of a contract. So that's really important to grok. The power of a contract is so imperative in all this. That's why we talk about commerce and contracts. So if you and I engage into a contract, what we state in that a contract, because we're two sentient beings of power, we engage into something with intention and we scribe it on the paper, right? So now we say the law is in that contract. There's nothing outside of that can change that. Nothing, not even the definitions. Right? So
essentially that is now superseding anything that is legislatively written.
That is exactly right. There is no court that can change that, so long as we're not stomping on somebody else's unalienable rights. So that's a really important thing. That's a discerning factor. So because the law is in the contract, nothing outside of that can change that, right? Now, like I said, the definitions. So we create the definitions. We write the definitions in the contract, and nobody can tell us that definition is right or wrong because we decided that as powerful creators. So now we talk about the Bill of Rights. What defines the definitions of the Bill of Rights of the Constitution? Well, it's the 1828 Webster's Dictionary. And it says what a person is or a people is a sentient living man or woman. Now let's scroll forward to the 14th Amendment. So what defines the definitions and the words in the 14th Amendment? It's the Black's Law dictionaries. So the Black's Law Dictionary, what it says a person is, or a person, it doesn't say anything about a people. A person is a corporate entity, a vessel, right? A partnership. Now it's got way, way down in the definitions, it might make a reference that it's about a sentient man or woman, but that's not really what its definition is. So to grok that is a very important fundamental distinction to understand. What is written in the contract is the law, and what defines the definitions is what creates the meaning behind what's going on in that contract, right? So when we found ourselves in the 14th Amendment, when we became 14th Amendment citizens after the Civil War, well, we essentially found ourselves into a corporate contract, right? And they had to move us as sentient men and women into a corporate fiction.
Did that have to do with the Organic Act?
That came
Not
shortly
yet.
after.
Not yet.
Okay,
Yeah.
got it.
I don't know if you guys want to talk a little bit more about.
This can be open discussion. Whoever answers.
Yeah, it was the 14th Amendment as well, because that created the U.S. citizen, which is in essence created by the state. The state can't create living men and women. That happens on the creator level. So we have this fictional overlay that occurred. And so the U.S. citizen is essentially an LLC created by the state, or it's a contracted piece of paper in a filing drawer in Washington, D.C. Now, the living man or woman becomes a surety or the responsible party on that entity, because any entity that's created, there has to be a responsible party behind it. So that's the partnership, the person partnership that is being discussed here. There's a partnership going on, and that's essentially the way that the living sentient moral being can be affected in commerce, or it's the way to interact in commerce is through this entity. So we unpack this fully, and we understand that we move into the commercial world later on. I don't want to jump too far ahead, but we're going to talk about it, the Banking Emergency and Relief Act in 1933. Well, the Federal Reserve went in 1913, and that's when they started Trading with the Enemy Act in 1917, which created enemies in commerce, and it happened during wartime powers, and that's when a lot of things were taken by the state in that process with people from Germany and foreign powers. Well, in 1933, there was the corporation went bankrupt, and so in order to put in the new banking system, which Daniel mentioned, the gold used to be backing things up, it's not any longer. So it's being backed up by the full faith and credit of the people of the nation, all the people of the nation. They use the word people there. However, it operates through the mechanism of the U.S. citizen, because during the 1933 Banking and Emergency Relief Act, they removed the previous exemption for U.S. citizens. So now U.S. citizens can be charged under the war powers to be enemies in commerce. So now why is this important? Because there was also a pledge made by Roosevelt and Congress, the federal government, that they would indemnify the Federal Reserve for bailing out the nation in the emergency. So all these charges that are coming through commerce, they call them charges. It doesn't matter where commerce is occurring. There's charges being made. And so that essentially that's how credit is generated in the system, through charge. And there's no longer any way to pay. We can only discharge. That's the normal result of a charge, is a discharge. It happens with light bulbs. It also happens. The analogy I use is like a keto. They bring a charge at us, and we can redirect it for discharge. So they do this through a contractual commercial mechanism. As I like to say, the federal government is like the HOA. Okay, the neighborhood was all the people of the nation and the states, but they needed to form an organization that would trim the hedges and secure the neighborhood, those type of things. That's the original intent. But now that, just like most HOAs are
the worst.
The worst.
Worst.
And they contractually keep taking more and more power and try to take away individual rights.
So you say we're going to build you a pool in 5 years and not do any of that?
Yeah, exactly.
But take your money.
Yeah, so that's a returning to the fact that there's private ownership, and the private and public's very important. If you want to pull out a dollar bill and look at it right now, this is legal tender for all debts, public and private. So I just want to stress that, and I'll pass it on. But we're being told that there's two ways to conduct ourselves in the system, and we need to look very closely at that, and which we will as we move along in this talk we're having here.
So I'd like to step back. You had mentioned the Organic Act of 1871. So during the Reconstruction period, which took place after the Civil War, when they took out Lincoln, They needed Lincoln out of the way so that they could start bringing in their commercial matters, right? That's when the 14th Amendment came into play, because that happened, I think, 4 or 5 years after they killed Lincoln, somewhere in that time period. So that gave, I think there's a saying that the 13th Amendment freed the slaves, the 14th Amendment enslaved everyone. So that was the new draft of the 13th Amendment. So there's an original draft of the 13th Amendment that was, I think, was ratified in 1812, I think, or 1813, somewhere in there.
Yeah, something like that.
And it had in there the Nobility Act, and it basically said that nobody of nobility can hold an office in the United States of America, right? So
Nor can they have any foreign ties to any foreign agents or governments, nothing like that.
right.
Yeah.
That's hilarious
So
now.
that means esquires, attorneys, right? Anyone of royal blood. So now we look at our system and it's just full of attorneys. It's full of esquires. So they had to figure out how to get rid of that 13th Amendment. So they rewrote the 13th Amendment as they drafted the new Constitution, and then the 14th Amendment came in play. And they kind of used that as a play for one of the deeper reasons of why the Civil Wars were enacted by the banks. It was just a financial thing, right? So they just used slavery as just a ploy, and it ended up being kind of a beautiful thing in the long run, if you will. But the truth of the matter is it just tricked people, everyone, into being slaves in the systems economically. That's really what it was all about. So they ensnared people as 14th Amendment citizens, as corporate citizens. And then in 1812, in the Organic Act, which they're always so
I
clever.
thought that was 1871.
1871. What did I just say?
1812. 1871.
Yeah, 1871. The
Organic
Organic Act came into play. And basically they housed the corporate United States within the 10 square miles of Washington, D.C. So, right. So
the Homeowners Association.
Yeah. So it was a private club. He calls it an HOA. I call it a PMA. It's a private association, and you got to sign up to be part of that. And when you sign up to that, you're bound by all the rules and regulations that are inside that contract, and the state cannot impede or impair upon that obligation. Right? Then we have all these obligations under these contracts.
So the one thing that I've always found confusing, and I'd love to hear all of your takes on this, if I may, is that there was originally the republic that was the United States, right? And that consisted essentially of individual nation states that were like the Republic of Texas and some of these other ones. I think there was roughly 37 or 36 at that time, that were unionized in a way so that they could have free trade between them, that they would allow flow of traffic between them. There wasn't actually like border checks and things like this, right? Similar to what's occurring right now, it seems to be with the European Union. But some would say that that republic no longer exists, and now we are a democracy. Some say, oh, no, we're still a democratic republic. Some would say, oh, we're operating both at the same time. The republic is still there, and then there's also this corporate fiction that operates under quote unquote democracy. So what's your take and understanding on that?
Yeah, if I can jump in here. So in short, the original republic does still exist. How do we know this? Because they give us a choice. Right? The 14th Amendment gives Americans a choice. You can be either a federal U.S. citizen or you can be a pre-Civil War state citizen, because that was the only political status that was available.
Do they explicitly state that anywhere?
No.
Okay.
But you have to look and you have to decipher, thick layers of dialectics and legalese, and look at other puzzle pieces such as the passport application.
Of course, that's what I was just about to say. In the passport application, it literally says on there multiple times, non-citizen national.
Mm-hmm. Now, that's the American Samoan only. A lot of people confuse that, right?
Okay.
So the non-citizen national, that's the American Samoan and the Swains Islanders only.
Got it.
And just a little side note, just to go off a tangent here, when you look a little bit deeper into American Samoa and Swains Island, you realize that those islands are still governed by common law. The people actually own the real title to their land. Abortion is basically a death penalty, I believe. And so it's the only 2 islands in the entire U.S. system that are not incorporated.
Interesting.
Right? So whenever they do something like that, go look at it, because they're trying to hide something there. And this is actually, believe it or not, where they hid the original pre-Civil War state citizen. They just gave it a new label, and that's just national.
Mm-hmm.
Just national, right? They define it in the Immigration Nationality Act, Section 101A21. It's also in the U.S. Code, I believe 8 U.S.C. 1101. a national owes permanent allegiance to a small s state, written with a small s. But then further down the line in section 101A36, they define the word state with a capital S, which is inclusive of DC. Okay. So now you understand capital S state of California, capital S state of Nevada, capital S state of Texas. Those are all the corporate fiction versions of the DC inclusive, right, overlay.
The municipalities.
The municipalities, exactly. So it's basically like a parallel system, right? So you have the corporate overlay, federal jurisdiction overlay, but the organic constitutional republic still exists. But it's up to each individual American to go back into that original republic, right? And so there's several ways to do that. Obviously, status correction is one way, you know.
Let's talk about that a little bit if we can, because that has become, that and I would also say state national has become a term that is thrown around all the time by everyone, and it can mean anything, it can mean nothing at the same time.
Yeah.
So why is saying state national incorrect? That term has always bothered me when I first heard it. I'm like, something is off about that, especially because everyone's like, yeah, I'm becoming a state national. And there are so many different quote unquote processes out there to supposedly become a state national, but that term has never sat right with me.
Because it doesn't exist. I mean, honestly, someone just came up with that term.
It's like a colloquial term, essentially.
Yeah, I mean, someone just made it up, right?
Colloquialism. Yeah,
and
that makes
then
sense.
then it's some kind of process that, I mean, I've seen some of the paperwork. It doesn't make sense to me, but you know, a lot of people are just resonating with it because it feels right, right? Yes, of course, they talk about the similar things that we're talking about, but then when it comes to the actual process of implementing the remedy, then it falls short, you know, and we often, you know, people come to us and then we have to clean it up, but it doesn't exist, right? So when we're talking about law, words mean things. Right. And so we can't just come up with our own words and believe that that's going to be the remedy we're looking for. So that's why, you know, I often say, just call yourself a national, because we hear this all the time from members, like, so who am I? What's the status? It's just national.
Or just living man, living woman.
Well, living man, yeah. But when you're looking for a remedy, right? When you're having to communicate with the system, they know what a national is, right? So they know. The IRS knows, the State Department knows, right? The state tax agencies know. They all know.
That's a real term that they use, is national.
Well, they know, yeah.
Yeah, okay.
Because it's been defined. It's in their own law books. So
Got it.
that's the golden egg, I like to say, right?
Yeah.
Don't come up with anything else. It's the golden egg. Let's use it.
And as you say, Daniel, you can open up your passport, page 2, and you open it up, the one that's facing you, the first one. It says U.S. citizen / national. Says it right there. They identify with that. They know what it means. It's actually on the application as well. I under penalty of perjury, I am a U.S. citizen / national. So they're giving you a choice. And just to chime in a little bit about this republic democracy thing, democracy is only of the federal government. That's an overlay. If you're a resident, which it means you're of the District of Columbia, but you're in a different nation state, whether it be California or Nevada, and so they acknowledge that the republic, we don't need to have all these mob rules and people voting on things. We have unalienable rights that are protected under the republic. We don't necessarily need to go out there and fight for those again. You know, I always point this out. If we have the Bill of Rights, then why would there need to be civil rights in the 60s? Because that's a bunch of fictional U.S. citizen corporations fighting for rights, okay? We don't need to change that system. In fact, it doesn't belong to us. It's fictional. It's a corporation. We can leave at any time and go back to the republic and live in that image and have different results. And I just want to point this out. We all know elite people go to private schools. They fly in private jets. They belong to private clubs. So you see a consistent word that's being used in all of those things.
Estates.
Private.
Okay. How about, you know, most people go to public school, go to the public pool, the public library. Okay. It's right in front of our face. Public equals democracy. Private equals republic. You know, let's just make it simple. So we get a choice, but we have to conduct our affairs in the republic and in the private. And that's the point of this. And that's what we're here to. The foundation of self-governance is a way to conduct your affairs in the private and be left alone by the public interference, because it's all contracts, and the contracts just like it comes from Article 1, Section 10, Clause 1, that no law shall be made to impair the obligation of contracts. That goes for private and public. Okay, so when we know how to contract properly, that clause protects you or it obligates you. So just think of it in those terms, and we can decide at any point in time. Going into that corporate system is like going into someone's house and they have a no shoe rule, and you come in with mud on your feet and think you can walk around and you're not going to get thrown out on your ear. It's not the way it works. You can go fight for that system, but it's inherently is a democracy, and mob's going to rule over in that parallel system. So why do that when we can just stand on our unalienable rights that can't be liened, and they are protected, and when we know what those are and we know how to stand on that, I'll just touch on this real quick before I pass it off. You're talking about the Constitution, going in the court and claiming the Constitution says this or that. That judge sitting on the bench is an administrative judge under the executive branch. That he's there to collect on the indemnification of the Federal Reserve, to carry out that pledge, and has nothing to do with the Constitution. And even by showing up in that court, if you don't know how to navigate that, you've contracted with that court and submitted to the full jurisdiction of that executive court. And so that's really at the root of things.
So I'm going to give an example of that. I'd love to share this example. So let's say you got a letter from the IRS and they said that you owed them money and you didn't pay them, and then they went to the courts to try to compel the performance of that contract. So you stand in front of the judge, you show up, you stand in front of the judge, and you think you know a little bit about the Constitution, and you say, Judge, I want you to dismiss this under the Fourth Amendment unreasonable search and seizure, because the judge confiscated some of your private documents to use against him, right? And that's a rightful idea. If you don't really fully understand what's going on, it's a rightful idea. So the judge's response is, the Constitution has no place in this matter. Literally. Has no place in the matter, because the judge is just there to compel the performance of a contract. Mm-hmm. So the judge is basically saying in his mind, you just don't realize that you're in a contract and I'm here to compel the performance. So people are standing there unwittingly. They don't really understand what's going on. The judge is not going to inform them. And that's what happens all the time. And people go in there with the right ideas and the right heart, but they're not in the right place. They're not in the right jurisdiction. They're not in the jurisdiction of the contract. They don't get that they're in that. So that's a big awareness for a lot of people.
Yeah, that's helpful to hear.
And I wanted to step back on something, because I think it's important to not overlook the importance of people that are trying to learn and they're trying to step forward. And there's millions of people that are stepping forward and they're learning about state nationals, American nationals. And the deeper truth of it is us as creators, we can create what it is that we want. The challenge with things like American nationals and state nationals is that they're just not recognized, and it's harder to work with. So everything that we do is completely and utterly validated and recognizable. And that's really essentially what we're talking about. I'm not a fan of poo-pooing on people trying to learn and people trying to figure their way out through this. I ultimately,
you want more people to do that.
I think it's
like
positive.
Absolutely, because like the more people
do
that, the more it overwhelms the system, so to speak, to where they're like, the cat's out of the bag at this point.
Yeah, it's phenomenal.
Seriously.
What's going on right now. It's phenomenal. It just makes it a little more challenging when it's not as recognized. And you can get recognition for it, but you got to know how to do it.
Yeah.
It's just a little bit more work,
Yeah. I have a couple questions on the Republic and on states as it applies to the Republic. So the first question I'll ask is there anyone that's actually in charge of the Republic that is still standing? Or is it just like there because they never went through a formal process of dismantling the Republic?
In some respects, the judicial, like, again, we're talking about executive branch being in the courthouse. There has to be Article 3 in the courthouse oversight and review. And when things are brought escalated to the Article 3, they need to uphold the Republic, and they need to uphold those principles. So
they're wearing two hats.
Yeah, exactly.
And Article 3 is common law courts.
Common law, equity, and admiralty maritime. Yeah.
Is it under the Republic or under the fictional democratic corporation that requires an oath of office?
That's a sticky one right there, because there are a lot of ones that are agents. They're agents of the executive branch. Executives kind of overran everything. And so that feeds back to the president because he's the head executive officer. So he definitely needs to be under oath, but all these other people could be acting under that capacity as well. So they're appointed, so to speak. So there are oaths that need to be taken out there, but again, that's one of the remedies is going and pulling their oath and things like that. If they're an executive branch administrative judge, they need to look up what that agency is, and it's not what you think it is. So to think that they're beholden to those certain rules, again, you need to know where you're at and who you're dealing with in those type of respects. So ultimately, the Constitution is not a granting of rights; it's a protection. It's a protection of unalienable rights, and same with the Bill of Rights. Those are protections on rights that were given to us by a higher authority, not man. And so when we enter into this fictional system, those are alienable rights, which are granted through contract. They're benefits and privileges. They even say that go into court and see somebody who has a driver's license. They'll make it clear that that's a benefit and a privilege. And when it's a benefit or privilege contractually, which are contractual terms, then they can be taken away as well. So that needs to be understood. But the right, Daniel can tell you the right the travel is not the same as operating a motor vehicle. And so, knowing these words, as Daniel was talking about the dialectics, they mean something. And when we use certain words, we are in essence consenting to that jurisdiction through the words that are being used. Because
I've heard this with respect to roads and traveling, by the way, because I've definitely explored the understanding that like what the definition of a driver is. It's someone conducting commerce on the roadways according to the Supreme Court and according to Black's Law, I think. But I've heard the counter argument that you're still using public roadways. What are your thoughts on that? I don't want to go off on a tangent on that because I think the point is not too important.
But it's quite simple because, we had public roadways in pre-Civil War America, right? And even after that, before they even introduced driver's licenses, which were voluntary at first. They were mandatory for commercial drivers because you had, if you're like hazardous material and stuff like that, you need special training. But at first, it was voluntary to have a driver's license. So, but we had public roadways then, right? And no one needed any license to travel on them.
It's a good point. It's a really good point. Okay, one more question on this regarding the Republic. And it's just because I'm so curious on this. I hope the audience is keeping up because I feel like some of this might be going over their heads, and that's okay. Is your film publicly available or is it only private?
It's for members only.
Okay. I highly recommend watching that film. Like it is really good. It's going to break down some of these concepts in ways we're going a little bit above and beyond.
And it's called Breaking the Spell, by the way, which we haven't brought forward yet.
Yeah, it's called Breaking the Spell. It's really, really, really good. Well done on that, by the way. I'm assuming y'all had a hand in that at some point too.
It was primarily you, I think, right?
Yeah.
Really, dude. Good. Well done. That was really well done. With respect to the Republic and states, so does that mean that the Republic of Texas still exists and then the state of Texas is a different entity? Are they synonymous? Are they completely different things? Is one part of the Republic and the other one is part of the fiction corporation? I'd love to hear your thoughts on that.
Well, I'll just, at least from our perspective in the national status correction, they both exist simultaneously.
Okay.
It's just that most people are a federal U.S. citizen, and so therefore they inhabit the overlay state of Texas, right? The corporate fiction. But for those that become nationals or state citizens again, they go back to the original Republic of Texas, right? But as Phil was mentioning, the courts have to honor both, right? And again, it's up to us to compel the court to honor which system or which republic, right? Which system we want them to recognize.
Got it.
Now, of course, that comes with lots of education and training and embodying the information, right?
The way I like in the court is it's like a general practitioner doctor. You got to go in there and get referred because they're going to presume automatically you're a U.S. citizen because that's just the presumption.
That's the standard, right?
And so when you go in there, they're gonna believe you're that. And so your chart or your record needs to show that you're not that, and then you get referred to the proper proper one that can administer that matter. And so it lives there. It's just not, if you go in there and demand it, you can have mixed results. But if you go in there and exhibit the behavior and provide the record of that, so that presumption doesn't stand, and there's ways to do that. I won't get into that right now. But then it goes to judicial oversight out of that executive administrative situation, and then that's where you can get that other remedy. So, and it doesn't have to go that way all the time, but we have that option.
So every day we experience, because people have, I hear this question all the time: does the republic still exist, and what's the difference between that and the United States? And instead of looking back in the history books and saying, oh, well, we can track historically what happened, we see the evidence in there, but it's hard to even trust history. So what we look at and what we experience every day is what tells us the truth. And what we experience is that the Constitution is still the highest law of the land. It is. We experience it every day because we put things into practice that express that.
Mm.
And so what I mean by that is a contract can never take away your unalienable rights unless you willingly do it, right? That's a deep thing to grok, right? So if you want to lean into that, if there's a contract that's trying to tell you that you have to give away all of your wealth and you willingly do it, well, that's on you. But if you wake up to that and go, wait a minute, according to the Constitution here, I actually have a right to earn a living without encumbrances, which means taxation. So we see every day that people express that and they win. So we know right there, that's evidence that the Constitution, that's just one of many, that the Constitution is still alive and well. It's still the highest law of the land.
That's really important to hit, just a little pin on that, and I want to revisit it later. That's really important for people to hear, because I know that there are many people who are out there listening and watching this right now who have done a variety of the processes out there, of which, again, there's so many, and feel like they may have messed it up and recontracted, so to speak.
That's right.
And they're like, well, now I'm screwed because I've recontracted after doing all this stuff. And it's like, no, you can always renegotiate and change the contract.
Absolutely.
And if I can bring in a little bit more context here, because these two systems exist simultaneously, and they knew they had to keep honoring the original republic, because otherwise everything would have fallen apart, because of natural law.
It's treasonous.
It's treasonous on top of everything else. So they had to make their new, commercial corporate overlay voluntary. Right. So, and that's why they also had to come up with a new 13th Amendment. So it says neither slavery nor involuntary servitude shall exist in the United States, blah, blah, blah. So, but they don't mention anything about voluntary servitude, right? So this is something that very few people talk about the 13th Amendment, even constitutional scholars, right? This is a concept called legal by omission. Right, I'm sure you're familiar with it, right? So in a nutshell, basically, in a contract, for example, I use a driver's license all the time. When you apply for a driver's license, they don't have to show you the 10,000 codes of regulations for traffic, but it's attached to that application. And once you sign it, you consent to all those statutes and codes. So same way here, right? 13th Amendment, legal by omission is that you can be a voluntary serf. You can volunteer into servitude through contracts. No one's forcing you to sign these contracts, right? You're doing it out of your own free will. And then right after that, followed up with the 14th Amendment, all persons born or naturalized within the United States, comma, and subject to the jurisdiction thereof. It doesn't say are subject to the jurisdiction thereof.
Ooh,
right?
That's interesting.
So just that one word, and, gives you a choice. So there's the ones that are and subject to the jurisdiction thereof, but there are the ones that are not.
Mm.
And those are the pre-Civil War state citizens.
Damn. I don't know if you wanted to finish your thought, because I did interject there.
No, it's gonna find its way back out eventually.
Okay. Sorry about that. I just had to say that because I know there are people out there that like, oh, damn it, I messed up my contractual relationship with them.
There's always a remedy.
Yeah.
There's always a remedy.
Yeah, there's always a remedy for contracts, and also receiving recontracting offers too. There's constant contracting going on. How many of you, everything you do now, you have to click a box somewhere, terms and conditions, or do this or that, but the point is to become conscious of how to navigate that and what it means, and know what you enter into. And we were talking about this on the way over here today. There's an equity maxim that says equity will not aid a volunteer. So that's very important. Daniel's talking about is voluntary, right? So we need to know the feel like we're forced to do anything is what the, using force, duress, coercion, force, and fear to gain consent. That's the program of the system to make it seem like you have to, but they limit options and they do these other things to get you to go in the direction that they want to
obfuscate for sure.
And they want to herd you in, so, but it ultimately always comes down to your choice, your self-empowerment, and gaining the knowledge to understand when you want to volunteer and when you do not want to volunteer, and also how to stay in honor with the system and not be subject to these rules. Like Daniel was saying, the license, if you have a driver's license, it says you agree to follow the rules of the road and you agree to this, and the 10,000 statutes attached to it, it just has one line saying you agree to all of that. And then you pulled over on the side of the road, and not knowing any better, you might start arguing or having a situation on the side of the road, but there's a contract with your consent attached to it that says you will comply. So again, they're just compelling performance, which means enforcing a contract obligation. That's all that's going on there. Or with let's say the IRS, let's say you voluntarily fill in a 1040 form at the end of the year under penalty of perjury. Well, if you understand what that is, you're actually willing the IRS as a pseudo-beneficiary into your state for that tax year, and that's what that contract is letting them do. And guess what? It's voluntary. Now you need to know how to navigate that process fully. However, when we start thinking in these terms, then it really comes down to self-governance, as we're here to talk about today, governing self, and it comes through the path of knowledge, and it comes through the path of understanding who we are in the system.
I think it's still so wild for people to wrap their heads around that with the IRS, because especially in more voluntarious but not understanding of equity and common law circles that you come across that are rightfully calling out how the government in its concept is based on coercion and force, and it's fundamentally immoral, point to things like this as quote unquote magic pieces of paper that work sometimes, but then they'll end up coming to get you eventually. But I always refer back to there's multiple former IRS agents and also multiple attorneys who flat out admit and acknowledge that they cannot find a code that lawfully compels you to file taxes. Like it really is on a voluntary basis, even at that level. And I know that's still within the confines of the fictitious corporation, but that says something that points to something that's really big and should be slapping us in the face. But the problem is when it comes to this sort of victim mentality with respect to our relationship to the government that many of us have adopted, we're not victimized by coercion and force. We're victimized by ignorance. We're victimized by misdirection and obfuscation, but we're not actually victims to the system.
Well said.
Yeah.
I often say you can't find your way to salvation through the lens of being a victim. This whole thing is about, not being a victim and finding our power, finding our self-governance, our self-agency. That's the whole crux of all of this. And who do we have an allegiance to? A contract with a corporate state or a creator? Like, who is our allegiance to? That you have that choice. And really, it is that choice. I mean, we can get biblical. We can get into the biblical elements of this because really it kind of finds its way into that. But we are in that crux in humanity. It's always been around. We're facing it right now in our particular common era.
Yeah, this is just the current iteration of it. Yeah.
And I want to speak to what you said about being informed and ignorance. There's maxims on that, which a maxim is a settled principle of law or a law and equity that's established and it's universally accepted by all. So these are the principles that law is based on. And so there's one that says ignorance of the facts may be an excuse, but ignorance of the law is never an excuse. And guess what? No one's obligated to teach us the law. That's what Michael was saying earlier about being in court. The judge is sitting there with the contract going, well, you don't understand what's going on here, but he's not going to teach you the law. That's not his position. And no one's obligated to do that. We have a duty to inquire in the doubtful matters to discover what's truly lawful. That's another maxim. So inquiring and taking it upon ourselves to find the knowledge. And And in all fairness, this knowledge hasn't been available very
That's what I was going to say. If you go to
readily.
law school, that's not really learning the law.
It's
Process.
learning
It's learning legalese.
legalese and admiralty maritime, the commercial jurisdiction,
Right.
the formalities, the forms, the procedures, and that's what form is all of that. So where the true remedy lies is in self-governance and self-agency, and that's in the private, because we talked about public and private, and we'll continue to talk about that. This is something that's private, and that's why we're here today to invite everyone in, and if they want to learn more, to come into the private, because these things can be shared there openly in that space, and that's what we're really here to do. And this is an opportunity. If you're hearing this, you have the opportunity to inquire into this and figure out more and learn how to navigate this properly. And that's what we're really out here to do today.
Amen.
Yeah.
Do you have anything?
I would just want to add one more thing. And because, they have to honor both systems, they had to put the principles and the lawful structures of the old republic into their fictional codes and regulations. They just gave it new labels, right? So the state citizen is now called a national. However, they don't limit it to just one different label. So, for example, you were talking about taxes, opening this up. Individual income tax, right? Title 28. 1.1-1, 111, very easy to remember, right? It's right there on the first page of Title 28.
26? Is it 26?
Title 26, sorry.
Yeah, 26.
Yeah, 26, thank you. The two statuses, right? First sentence, I'm paraphrasing now, but basically, everyone who is a U.S. citizen or a citizen of the United States and resident own income tax on everything they make. And, again, comma, and to the extent of 871B and 877B, on the income of non-resident alien. Well, what is a non-resident alien? Right? Interesting. So anyway, so we have these two statuses, right, in the first sentence of the income tax. So then when you go look at 871B and 877B, something very interesting happens. One of them is, I always mix them up, but one of them is an expatriation tax. Well, my question to you is, well, how is a non-resident alien expatriating, right? If they're not even a citizen. Okay, the other one is if you make any proceeds on federal bonds or if you have a business inside the District of Columbia. Well, okay, interesting. And then you realize, oh, wait a second. Those two are the only constitutional taxes in pre-Civil War America. The only two taxes that state citizens had to pay. Okay, if you leave, you give up your citizenship, expatriation, okay, if you have a business inside DC, all right, there's a tax for that. And the rest doesn't exist. So you see, they call it national here at the State Department, and they call it a non-resident alien in the tax code to confuse you, right? That's the dialectics aspect of it.
Man, so wild. Most of you are already aware that our everyday devices are taking a real toll on human biology. Talking about our laptops, our tablets, our phones. Each one of these is hitting you with non-native EMFs, artificial light, excessive blue light, and constant screen flicker. And most of us are feeling the harmful effects whether we realize it or not. But there is a better option. Daylight Computer is actually solving all these problems at the root. And I had an awesome conversation with Tristan Scott from Daylight on episode 202, breaking all this down. Here's a brief clip from the episode.
We have a reflective display technology, similar to a Kindle, which was really the inspiration behind the product overall. It's really intended to be a magic piece of paper. And the reflective technology works just like everything else in nature.
What are some differences between this and a Kindle?
Kindle was the inspiration, but it was limited. It's great for reading, for turn paging, but if you try and do anything else, it's too slow. We wanted to bring a display technology that feels like digital paper, but can do more. It can do email, it can go on the internet, it can go on social media. We created a Kindle on steroids, which now means it's a healthier iPad.
All right, so if you'd like to check out Daylight for yourself, just head to daylightcomputer.com or just head to the show notes and enter code TWF50 at checkout for $50 off your order. And if you're a member of the wayforward.com, just head to the member marketplace and you'll find an even greater member exclusive discount waiting for you there. I have a question about the birth certificate. I think maybe it'd be appropriate to talk about that a little bit and the supposed trust that is established, because a lot of people are interested in that, and I think rightfully so, to know what exactly is the nature of the relationship as between us as the living men or woman with that entity that was set up. What is that entity? Who owns that entity? Is there elements of it that are copyrighted that we can't actually, there's processes out there where you like copyright it yourself, et cetera, et cetera, et cetera. But from my understanding on the birth certificate, it came about as a result of the Maternity Act in the 1920s. Are you all familiar with that at all?
Yeah, so I'm somewhat familiar. We don't go too much down that rabbit hole, but
Yeah, I know it's really linked in with the vital statistics laws as well. The who owns it, it's certified, it's a certified copy, which is a commercial term. So that's how it enters into the commerce and into that. It has a bond number attached to it, which is the original security for all other securities to be leveraged against. And in some respect, it is the collateral for the Federal Reserve bailout of the public credit, which I call the debt system, because that they needed to have collateral. There's no gold or silver to collateralize. They already took all that back in 1933.
Some will call it the future labor interest deposit.
That's exactly what it is. How much milk is the cow going to produce over its lifetime? How much can we count on that? Let's fund that account. And that's where all the charges, all the credit charges, all go against that account. That's why, for instance, somebody that goes to jail, for instance, they call it discharge from jail, right? So they're charged in court, but they're discharged later. So that time that they spend inside is discharging that amount, and it's coming from the account. But if your account, if the charges are $400 million, how long does that take the work off from the account? Those type of things. We don't like to get too much into it because that's a big rabbit hole.
Huge rabbit hole. That's what I learned too.
And to find and answer that, we have to understand it's their system. Most likely those type of things are held in trust with the private trust, the Federal Reserve, as collateral for funding the system. And that's private. It can't be audited. For all those of you that don't know, the Federal Reserve is a private trust that cannot be audited. Okay. Think about that. Okay. So let's just throw that one out there. But so we operate in a different way. If we're being presented credit charges in the system, no matter what they are, and they call every function is called a charge, then we have a power to discharge, and we can do that with Federal Reserve notes. That's one form of legal tender. Or we can use the other type of legal tender, bills, which if some of you are familiar with bills of exchange. But how does that process work? Well, again, inviting you to step into the private to learn more about that, because that's, why not just navigate the system consciously and from an empowered, responsible position, and stop running away or having any angst concerning it. It's an opportunity to go to peace and just manage your business from a responsible manner. So that's more of our stance. Mm-hmm. It's not, again, that's a corporate system overlay. Do we want to spend our time over there? Or do we want to spend our time building our lives and affairs in the private and being left alone by that overlay? And that's really what it's about to us.
It's like your position is essentially understanding that, okay, that fictitious entity was created, a trust was likely established, we have some relationship to that. Anytime a trust is created, that means the grantor granted property to the trust. It was likely the placenta or something like this. That's what Govinda, who I just recently interviewed back, I think episode 193 by the time this airs. So you can go check that out for more info on that. But you're of the position that, okay, yeah, all that is likely true, but we don't need to get caught in the weeds on it because we already have remedy outside of it that supersedes even needing to go into the codes, acts, and statutes in the first place.
Mm-hmm.
Yeah.
Okay.
It's important stuff to wrap your mind around. It's another rabbit hole to go down if you want to go down that rabbit hole. But ultimately, you don't need to know that. It's not really vital information to know to self-govern. It just isn't.
Got it.
So that's why I was saying we don't usually go down that rabbit hole that much. We don't talk about the birth certificates that much in the fellowship because it's not something that's really super necessary to know. It can just be another distraction.
Yeah,
of getting down to what's real.
That's totally fair from the equity perspective. Like that makes a lot of sense too. And we'll get to what equity is later on this episode. I kind of want to end with that. We're just like building this up.
To it, yeah.
I do have one thing that I'd like you all to clarify because I just don't think I am fit to clarify this. But I think people can get pretty confused with bills of exchange, promissory notes, and how what we're dealing with now with Federal Reserve notes, those little dollar bills that we carry around, aren't actually money. I know we mentioned it a little bit. We talked about how our money was taken off of the gold standard. So now we just have currency, fiat currency, right? And it's literally just debt notes. So can we talk about that just a little bit more specifically?
So we have all heard the term legal tender. So we lawful tender or just tender was in the Article 1, Section 10, gold and silver. So now we moved in the legal tender in 1933 through public policy, which is a fictional overlay, an enactment. So what that did is we all think, because the language in that policy in HJR 192, it says including Federal Reserve notes. Okay, so when the law says including but not limited to, they're obscuring other parts that are connected. So when you read into it more and you read the discussion and what's actually in there, then you start to see that there's bills of exchange are listed in there. There's also trade acceptances, banker acceptances, all these different forms of legal tender. So if we're only taught that there's promissory notes, which a promissory note is one form of legal tender, and that's a promise to pay, an IOU.
And that's what these Federal Reserve notes represent. Yeah,
yes.
Just to be clear, what we're getting at here is when they say including, but they don't have but limited to, right? Like they're not saying that there isn't other options, right?
Yes.
What they're referring to is that when you get charged by a credit card company, by a dealership, et cetera, et cetera, et cetera. And I would like to talk about like securitized debt versus unsecuritized debt too, if we could later on.
Yeah.
But nonetheless, what we're kind of getting at here, correct me if I'm wrong, is that it's not just Federal Reserve notes that you can pay with. There are other ways to discharge that debt. Federal Reserve note, when you're quote unquote paying someone, that's just a way that you are discharging the debt.
100%. It's in quotes. I like that that payment is in quotes.
Yeah, exactly.
Because we were told when gold and silver was taken away in 33 that requiring payment in gold and silver is against public policy. So we can't pay anymore. They told us we can't pay.
No one's paying for anything anymore.
We're not. We're just passing debt around and credit. We're passing credit around.
Yeah.
And the payment now customarily is, like you're saying, Alec, is discharging with Federal Reserve notes. If we think that that's the only way to discharge, then we're missing out on 90% of the financial system and money supply, which operates through bills. And bills and drafts are orders to pay or accept. So that's what they are. So when you're presented a bill and that the bill, we know they're bills. We call them bills, right? They come in the mailbox. Oh, I got a bill from the IRS or this creditor or whatever. We're told what they are. Now, how many of us were told how to operate in that branch of legal tender?
No one.
Well, not anyone that went to public school or public whatever. I'll just tell you that right now. However,
not bar card holders. Absolutely
yeah,
not.
exactly. And 90% of what's going on in the financial system is operating through corporate paper or bills, and so just think about that for a second. And so what they really are in this system, because we can't pay anymore, they're a request or an order or demand for a credit issuance. So the law says, under one of the maxims of contract, says the way a thing is done, it's also undone. So what started it? Okay. So that in equity, we always look back at we want to rip it out by the root, right? Like a weed, you want to just cut it off. You want to, remove it and remove the root cause. And so not dealing with that. And so I don't want to get too far off topic, but I hope that was simple. There's two families in legal tender: notes, promissory notes, they're promises to pay, and bills and drafts, which are orders to pay or accept. So there's two branches, and if we're only functioning in one, then most likely we're just going to be the debtor in every situation and obligated, because those are IOUs. And we all have to sweat and work hard to get those IOUs. They just don't hand those out. But however, on the other side, when we're presented, and I want everyone to pull out a bill they have laying around as well. Look at the sum on there that they're saying that you owe. Is there a minus or parentheses around that? Is it a debit in bookkeeping, or could that be a credit? That's on the face of that. Now, if you know how to properly honor that and process that, then you get a completely different result, and you hold a completely different situation. I always tell everyone this too: when we receive something with our name on it, we're liable for that. We have a liability and a power. We're not told about the power. We're only taught to embrace and consent to that liability and be the debtor on that instrument. Now, how about thinking about for a moment, hey, there's a completely different position I can take. We all know the elites that go to private schools and private colleges and private everything, fly in private jets. They don't seem to ever get ensnared in taxes or go to jail. And I'm not saying they never do, but a lot of them don't.
If they stomped on somebody's rights, then they'll probably find their way there.
Exactly. But if it's pure commerce, people call it a loophole. Let's go back to not being ignorant of the law. Okay, if we have a duty to inform ourselves, then we can also. It's not a loophole. We just know how to process through the law to the letter of the law, and that's the important part. So I hope that was clear enough to kind of break down.
It's hard to teach that to a 5-year-old. It probably
totally
needs to be broken down in a whole different way.
It can be very confusing. The financial system's confusing as it is. So for people to really understand, wait, fiat currency is literally just debt notes. That's all that it is. But what does that actually mean? So I think you broke it down really well.
It just goes back to how much milk's the cow going to produce over its lifetime,
right?
Mm-hmm.
And how can we best siphon that life force off?
Yep.
For our purposes and our advantage. And that's you can't go to somebody and they do, but the mob used to do this. They go to a business and say, hey, you got to pay for security, and all this, and they'd shake you down, right? Well, the system is a little too proud to beg for what lawfully they need or what they need. They need credit. So instead of coming and saying, hey, you're the source of credit in the system, and will you please give us some credit? They're too proud to beg. They had developed an elaborate system to come and get it from you one way or another.
Right.
Now, how good would it feel to be empowered and just know how to navigate that instead not have to be shook down and be compelled and go through the gauntlet to give them what they need anyways? Why not? Why not just be empowered and manage your affairs in a way that they just get what they need and go away? And that's the point.
I feel like it's important to create a distinction. So you were earlier talking about the Emergency Banking Act of 1933, and this is what I call the Great Switcheroo, where they took away the substance of our money, which was gold and silver, and they replaced it with the people. So in the public side, the U.S. citizen, the corporate citizen, became the creditor. That became the debtor. They became the responsible party for all the debt that the corporate state created.
And that's the future labor interest deposit that was the birth certificate.
Yeah.
Right. So that's how that fits in there.
And that's what you're talking about with milking the cow, right? They're milking us. We're literally what backs the currency.
Yep.
That's the thing.
So that's the public side. So that's the public side. I want to try to create a distinction to help people a little bit. And then you've got the private side. So the private side is the living sentient men and women that is actually literally the currency and the energy that animates this corporate fiction. This hollow body over here cannot exist without our interest, without our energy and currency, right? So take that in. So there's a book, Modern Money Mechanics, that was written by the Federal Reserve of Chicago. And there's a section in there that I think it's titled, How Was Money Created? Essentially, it's how was credit created? And it says that the process starts with our signature. So now we're talking about the private side here. When the sentient being, the creator, the currency, offers the signature.
The sign of nature.
The sign of nature.
Ooh.
That's
How have I never heard that?
Right? Isn't that powerful?
Logically, wow.
That's what starts the process in the public for the bonding and the drawing off of that trust thing that everybody talks about. And we know it's there because we work off of it, but I don't give a shit how much is in it. Honestly, I don't care. But we know it's there because we see it happen. So we've got the public side where we're the debtors unwittingly, and then we've got the private side where we are the currency of the system. We have a lot of power and responsibility when we become aware of that. So that's why we love to teach people the distinction between the public and the private, what you are in the public and what you are in the private, and how you can manage life in the public with a lot more power and a lot more authority, and how you can protect your life in the private when you have that awareness of power.
Beautifully said. Beautifully said. So I know you mentioned a couple times the Foundation for Self-Governance. Is that what it's called?
Yeah, within the fellowship itself, our core teachings are the foundation for self-governance. So that steps back to what I was saying a little bit earlier about the original organic constitution is designed to limit the legislative powers of government. So the people could remain in self-governance. So we teach people how to self-govern again. That's the whole essence. And I do want to highlight the Breaking the Spell film for just a moment, because it's just a great starting point for a lot of people. It helps them orient and create the context of why they might want to step into self-governance.
It is a really amazing film. Legitimately, I mean that.
Yeah, thank you. Thanks for
man.
saying that. Yeah, we're getting a lot of reviews from people saying the same thing. So thank you for that. So you start out in that place, right? Then you have some context, and then you can step into the foundation for self-governance. So the foundation for self-governance has 4 pathways, and it's not in any particular order. It's national status passport, trifecta, Allodial land, and equity, and they work separately in their own rights, and they work best collectively. So we've worked them in as a collective because we found it to be the most useful and practical way to apply these practices and principles in your life without getting into the paralysis of analysis, right? Because that happens to a lot of people. They get stuck in that loop and they don't put anything into work.
It's because there's so much floating out there right now. Like there's so many different processes out there.
There are, for sure. And again, I'm happy there are.
Mm-hmm.
I'm super happy that there are. And we designed this to be practically used. That was the whole purpose of this. Distill it all down, wash away all the bullshit. Let's just get to the heart of the matter, commerce and contracts, and let's show you how you can build your life in the private and navigate your life, aspects of your life in the public with a lot more power, just like I was saying a moment ago. So national status passport, Daniel, you might as well just break into that. And then I know you had some other questions.
I have one quick question before that, actually, that I just thought of too. And I think this is a good point to make regarding the international applicability of this. So the question that I'll ask to sort of open that box a little bit is, from my current understanding, I know I'm saying that a lot on this podcast, from my current understanding, but I have learned that because the United States is unique in that it has the fictitious corporation, it has the original nation states that were a part of the republic, and then the land. There are actually multiple ways to skin a cat, so to speak. There are multiple ways to go about renegotiating, recontracting, et cetera, with the fictitious corporation, all of the elements under its jurisdiction, versus many of the other nations out there. I don't know what the appropriate term is. Would it be nation?
Nations.
Yeah, many
states.
of the other nations states out there, they have the fictitious corporation than just the land. Is that your understanding as well?
I think it depends on the individual history of the nation we're talking about.
Okay.
I mean, Germany, from my standpoint, because I grew up there, has a very complex history. There's a similar movement there happening now, which I don't know too much about, but they're basically trying to do the same thing that what we're doing here with the status correction, going back to the pre-corporate overlay that happened after World War II. But I don't know how effective it is.
Got it. I mean, I'm sure it can present a lot of complexities because I know you can't even say Hitler's name in Germany. So.
Right, yeah.
From our understanding and our research, it's pretty clear that the vast majority of the world has this corporate overlay. Mm-hmm. I mean, we definitely know through practice and through study and awareness that the international banking cartel has that corporate entity structure control through the entire world. And they've systematically done this over a myriad of years. You can learn a lot about that in Griffin's book, The Creature from Jekyll Island. He talks a lot about that, and it's very accurate. So, and we have our own, when we're in practice of this, sharing this with people, you're talking about international applicability in regards to equity. So that's one of the 4 pathways. It's applicable in 140 different countries as far as we know?
Well, it's at the root of common law systems. It's at the root of civil law systems. This make up over 150 nations worldwide. But then we have to think about the international trade. Nations can only agree on the law of nations or on natural justice at the foundation because they're fictional enactments and all their things they put on in their nation. They can't really agree on most of that stuff, so they have to default to natural justice, but also they have to agree on commerce because that's what it's really about. So they have to agree on how these negotiable instruments are exchanged and the rules having to do with that based on the law merchant is where it came from. And if they're a member of the IMF and the international trade community, they are functioning, as Michael's saying, that this whole commercial banking financial system, it's all intertwined. Now, The dates may change and vary in nations, like when they left the gold standard and moved to public credit, but they're all doing it. So there's these fundamentals in equity. Equity is actually it's natural justice from the Creator, and it works for private, living, sentient, moral beings, men and women, and those are everywhere around the planet as well. So it doesn't change the fact that, as Michael was saying earlier, this fictitious system is animated by the substance, the living beings. And so that's where equity lives. And I want to be clear about that. So we have people all over the world using equity to settle their matters and be left alone by the public system.
Yeah, so it's very clear just from the aspect of the financial world that it's all over the world. That's unequivocally true. So that would be one of the, I'm just going to bring this into the pathway. So equity, that's very clear that equity is usable and applicable all over the world. So in regards to the other pathways, the national status passport, it has certain limitations. So the national status passport completely functions within the United States. As Daniel was just saying, countries are looking into ways where they can do the same thing that we're doing in the United States, because it's there. It's workable. People just have to figure it out.
It has to be somewhere, yeah.
And then the trifecta, which is one of the pathways as well, it's built on trusts. Okay, so you have, the trifecta has three pieces. It has the church, the trust, and then unincorporated associations, or PMAs. And really, they're all unincorporated associations. If you want to
I
look
think
at that.
PMA is just a colloquial term that people use, right? But what we're talking about is unincorporated private-based organizations.
That's it.
Or
They're private
unincorporated-
clubs.
Yeah.
They're simply put, they're private clubs. It's people assembling. That's all it is. And they're assembling under contract, right?
Which we have the right to do.
We have the right to do.
Yeah.
So in the United States, and really this is applicable all over the world as well. So I'll break it down for just a moment, that the church itself is recognized all over the world. And in the Trifecta curriculum, I've gone through and brought forth a bunch of biblical references and ancient texts and philosophical texts showing that it states that the man's body is his church temple. And in the presence of God, in the presence of Source, what comes out of your mouth and the actions you take are your ministry, right? So we're always, if you get that, so we're always talking about the substance and the form. When you get the substance, we're always in our church ministry. And you don't have to look at it from a religious context. Just look at it from a truth context. Just look at it from as we are actually the creators. We are source creation. And then there seems to be this entity out here that's trying to mimic our creation by stealing our juice, right? If you put it in that context, it really helps people kind of work through their feeling like they're doing something wrong or they're hacking something. But the truth is somebody's been hacking us,
Amen.
right?
Amen.
So let's just find that awareness.
And maybe some religious programming does come into that, though, too, with respect to us, like feeling that we need to be ashamed and guilty with our relationship to government. Maybe like Catholic programming there for those who are Catholic listening to this.
Yeah, well, I was raised in Catholicism.
Oh, so you know like the Catholic guilt? That's a thing.
Oh, dude, it's rich. It's
Yeah.
rich. I always called it the hollow box, but that's why I walked out of it. And
Man.
yeah. And anyway, that's a whole wow, could we go down that rabbit hole for days?
Yeah,
I'm going to really hold off and not do it.
Yeah, maybe a part two.
Part two. Okay,
Yeah,
part two.
yeah.
That sounds good.
So maybe we should unpack what it means to actually status correct, because we kind of danced around it and we defined the difference between a state national, which is not a real thing, versus a national, which is a term that they recognize. And what we're really swimming around there, dancing around, is the status correction. And again, that's a term that is thrown around all over the place to where it's lost all meaning. So
so we'll come back to the applicability, because I don't want to forget that fact. I'm totally great with just like picking
My bad,
apart the
sorry.
No, it's great. It's totally great. Let's flow with it. Just jam out the NSP and we'll circle back around.
So first of all, yeah, I agree. I don't even like the term status correction, really, to be honest with you, because it implies something being incorrect, when in fact, as we discussed, it's just our voluntary consent to it. You know, we're just, you're a U.S. citizen? Whenever you hear that question, most Americans say what?
Yes.
Yes. And the second question after that is usually, are you a resident of your county usually, or a city, whatever, right? So those two words are coming from the 14th Amendment. So that's why they have to keep asking those questions, because it is voluntary, right? But let's start at the beginning. Okay, so what is status correction? Well, to make it really simple, your status is basically what your passport represents, right? So, and who gives you a passport? It's the U.S. Secretary of State, right? So in order for the U.S. Secretary of State to give you a passport, he needs to know what your political status is, right? So there's actually a Supreme Court case decision from 1835. It's called Urturtiqui v. Darbel. Don't ask me to spell it. It's a very weird name. But anyway, 1835, and it still stands today. And it says basically, in essence, the nutshell version of it is that whatever is in the possession of the U.S. Secretary of State as it pertains to your political status, that's the highest and best evidence for your status. Okay?
Interesting.
Because he has to issue a passport. The passport is the highest standing form of identification in any country. It adheres to the law of nations. It has to. So, okay, so now that we know that, okay, so if I want to correct my status, you have to start at the root, right? And we were talking about, the root. Okay, and that's the U.S. Secretary of State. Great. Now, okay, we have the highest form of ID, highest standing form of ID, U.S. Secretary. Okay, well, what is the highest form of truth in law? That's an affidavit, right? An affidavit is a voluntary written statement of your truth, right? Usually notarized, hopefully notarized, okay, signed under penalty of perjury. And so now that we understand that, okay, what if I send an affidavit claiming myself to be a national because I know it's there, it's in the codes, right? And I know it's the original state citizen, send that to the U.S. Secretary of State, and now it's on file. Again, whatever's on file with the U.S. Secretary of State is the highest form of truth as it pertains to my standing and status, right? Okay, so that's the first step. There you go. And then the next step after that, obviously, is to get a passport with that status. And you can either do a renewal, DS-82, or get a new passport, DS-11. It doesn't really matter because what matters is the oath. We talked about it a little bit earlier, right? So the oath on the passport application, I encourage everyone at home to read the oath, right? I'm paraphrasing it now, but the first section of the oath says, I declare under penalty of perjury that I am a citizen or non-citizen national of the United States and have not performed any of the criminal acts listed under the description, blah, blah, blah. And then at the end of the first sentence, there's a parenthesis that says, unless explanatory statement is attached. Okay? So they're basically saying, just to decipher the legalese here, okay, I declare under penalty of perjury that I'm a U.S. citizen unless I tell you otherwise in my explanatory statement, which I can attach. And then you can go to the next page or the page before that. It says, false documents or false things you attach to this application, including affidavits, everything will be reviewed. And if you include false documents, we're going to slap you with all these US codes. Well, what if I attach a document that is truthful and is not false, such as my national status affidavit? So that's what you do, right? You attach the affidavit to the passport application, send it in, and then you get your national passport back. It's not going to look any different, right? A lot of people think, well, where's the do not detain stamped or something? Where's the difference?
Like, where's it better have 5 stars or it's not legitimate?
Right. The stars don't matter.
They don't matter.
No. What matters is, again, what's in the possession of the U.S. Secretary of State. That's all that matters. Okay, so you get your passport back, and it's going to have a do not detain code programmed into it. How do we know that? Well, we have many videos proving that. We actually have a video from a sheriff in Florida that ran the passport card and confirms on camera that, yes, it says do not detain. So why does it say do not detain? Well, because you're a common law pre-Civil War state citizen that cannot be detained for victimless crimes such as running a red light or running a stop sign. As long as you didn't injure anyone, there is no crime, right? So, and then you have your passport. Okay, great. What's the next step? Well, then you send your affidavit to, other federal agencies, of course, the IRS. It needs to be notified. And then you start at the state level. So Attorney General, because he's in charge of all the laws of your state. Then you go down to the county level, district attorney, the public health officer because they're trying to weaponize that position now, as we've seen. Yeah, and then really you can notify anyone you want, but there's a certain list of people and offices that you should notify to sort of complete the status correction circle, right? But it all rests on the affidavit that is on file with the U.S. Secretary. And this is our remedy, right? If anyone comes and challenges us, then we show them, okay, here's my affidavit, here's my delivery confirmation to the U.S. Secretary. My status has changed. There's nothing you can do. And that's what we stand on.
Boom.
Boom.
Well said. Wow. That's amazing. Wow.
So you had asked, what does it mean, right? What does it mean? Is that the question you posed? What does it mean to be?
Yeah, to like actually correct your status.
Yeah. So what does it mean? Right. So let's unpack that for a minute. Like,
simply it means you're exiting the federal corporation overlay U.S. citizen fictional title, and you go back to original pre-Civil War America as a state citizen. That's all it means.
So I'm sorry, I just feel like posing this question because people ask it all the time. Well, what happens with my life when I do the status change? Like, what does it mean when I actually do a status change? How does it affect my life?
Well, that depends largely on you. I mean, we often say nothing really happens except that you're being left alone by, the goons.
Your standing has changed. Your relationship with the fictitious entity and all of its agents has changed.
Exactly. It's just a relationship.
Yeah. I wanted to pose that because people they get scared. They think, oh my gosh, I'm going to change this. My whole life changes. I can't go to the public library anymore. I can't drive my car. No, absolutely. You can do anything as a living sentient being. You're doing it in just a different status, but you don't look different. You don't act different. You have a different way of managing life.
Yeah.
And on the backside of things.
And if anything, you act more honorably, more peaceful, more loving, but more confident at the same time.
Yes.
That's what you do.
Yeah.
Because that's a good point, and I was going to make that too, is that the only thing that really changes is your inside.
Mm-hmm.
You change internally because, it's pretty scary. You were sending an affidavit to the IRS, right? Because in this process, you're going to encounter a lot of hidden fears that you didn't even know were there, right? So I think it's a very spiritual process, actually. So you're overcoming fear and you're gaining more confidence. So it's really your internal life that changes the most, I would say.
Do y'all discuss in the fellowship overcoming those fears and things like that as well?
Yeah.
All the time. It's a big part of the process.
Yeah. I mean, it really is a spiritual thing. Like you can do all the paperwork, but if you don't understand it spiritually, A, it's not going to stick as well as it could. And B, you're missing the whole point.
Yeah. We often talk about substance over form. The substance is the currency, the energy, the creative godliness, and the form is the intention that's scribed on the paper.
Yeah.
There's also a distinction between capacity and status. Capacity is how we're functioning with the divine in our divine alignment, and that is spiritual. But that's who we are as a living, breathing, sentient moral being under the Creator. And our status is how we interact with those around us. So to say you're going to exercise status without having the capacity to embody what you were talking about, Alec, the energy field of confidence, peace, and in most cases, genuine inquisitiveness into things, and that's how we learn. If we're not embodying that in our proper capacity, then it may just be a piece of paper, because then we may not conduct ourselves in the proper manner. But it's very important to know who we are first. We talk a lot about that too, as far as substance and form, knowing who we are and know what capacity we're standing in and how we relate in our status to those around us.
Well said. So you were talking about applicability, and I'm sorry that I shifted over to him.
It's great.
It was burning in my mind.
I love the flow. Yeah, I get it.
The status correction thing was burning in my mind because I know he missed it earlier. So
yeah, I know that can be torturous. Just stepping back to the four pathways: national status, passport, trifecta, allodial land, and equity. We've already established, and I know we're going to pick apart equity a lot more here in just a bit, but equity clearly in the financial element of things, when you're expressing equity, which is an amazing thing to learn, that it's applicable all over the world. NSP has its restrictions in regards to the United States, and pardon me for calling it NSP, but that's what we call it internally. The trifecta is applicable all over the world as well, because it's based on trust. It's based on a church and a trust, and the church have already established it's this, it's the substance, right? But we establish it in an actual written intentional church. And we start out with what's called the Declaration of Knowingness. right? That's where you're pulling your essence out of the ethers, and you're drawing your intentions down and you're scribing it into paper in the realm of, what do you know today? Who are you today? What is your relationship with source, right? So you have to start from that point, right? And then when you establish that, you're bringing that essence out into the physical third dimensional world, and you're doing God's work. So there's the opening of the church, right? And now you're bringing that into the world. And the church doesn't want to navigate the Babylonian system of commerce. So it opens up an integrated auxiliary that's a church, that's a trust. Now the trust is the fiduciary. Trusts are recognized internationally, and you can even look up the Hague Convention of 1984 and 85, and it clearly states that they've got like the recognized aspects of what trusts are internationally. So every country in the world recognizes trust in a uniform fashion. It's really powerful. It's kind of like the Uniform Commercial Code for trusts. So trusts are recognized, and you can navigate fiduciary responsibilities. You can have bank accounts. You can own property. You can have assets. You can hold assets. You can open other trusts. There's all kinds of cool strategies that you can navigate using trusts, right? And then there's the private clubs. So the way that we navigate it in the Trifecta is you have the church that's established, and it has the integrated auxiliary, the fiduciary of the trust. And then you have what we call church projects or private clubs. They're in the likes of businesses, if you will, public businesses that they just don't have licenses and they don't have permits. They're acting in the private completely. So, and all of that is by the will of the church. So they can, like the Sacred Honor Education and Fellowship is a private club, and it doesn't hold a bank account. The trust is the fiduciary. It's the one that was held responsible for the fiduciary responsibilities of all the projects, right? So you can hold a bunch of different bank accounts for different projects, and everything is housed within this administrative trust and Trifecta foundation. Really, that's kind of how it works. And it is definitely recognized internationally. Churches and trusts are and private clubs and private associations are recognized. They just have different languages and different usabilities. Now, trust laws are a little bit different in each country, so you have to do a little bit of study in different countries.
But most Commonwealth countries are going to be generally the same, right?
Absolutely, absolutely. Very, very recognizable.
Okay, so England, Australia.
Yes,
yeah,
very much so.
Canada.
Yeah. So I did want to express that this is an important thing to get. This is where people get confused when we talk about the public and the private, and some people think, oh, I'm going to exit the system, I'm going to be totally in the private. Like, how do I exist with my life in the world today if I move everything into the private? So that's why we're always talking about you build your life into the private. Just like Phil was saying earlier, the elites do everything in the private. They build their life in the private through these private trusts and these associations. There's all kinds of associations that the Bar Association is a private association. The American Medical Association is a private. They're all private clubs.
Right.
Same with pretty much central banks. I mean, they're private trusts as well.
So everything is built in the private. So we teach you how to build your life in the private so you can actually build real life legacy that you're actually protecting that's out of the jurisdiction of the corporate state. So they can't confiscate it away from you. They can't leak away the wealth through taxation. They can't confiscate it through contracts, right? You learn how to protect your real legacy wealth, and you can pass it on in legacy if that's what you want to do with it. However, you can still navigate with LLCs and public-facing entities. You just have to honor that contract.
Mm-hmm.
So there it is, to know what you're getting into. So an LLC is a fine thing. It's a fine pass-through thing to work through if that's what you need. If you need a permit, if you need a license, if you're a doctor or something and you need to navigate patented products that are controlled by the corporate state, then
you're receiving limited liability and bankruptcy protection, though, too, from the state if you have an LLC, right?
Contractually.
Yeah.
Yeah. I mean, there's benefits to using those.
Well, that's what I'm saying, though, too, is like, isn't that recontracting you with them in some way, though, too, if you're receiving those benefits?
Well, the benefits are a product of the initial contract to create the LLC with the state.
Yeah.
So there's obligations in there as well.
Yes, that's what I'm saying. That's what I mean, obligations.
Yeah.
But the obligations are with the LLC, not the trust.
Yeah.
The obligation is not with anything beyond that entity of the LLC.
And LLCs are pass-through entities, so it passes through. Well, now where's it passing through to?
That's a good question to ask.
Right.
Yeah, that makes sense. I see where you're getting at now. Okay.
So there's a lot to learn, and we share all that within in the curriculum of the Trifecta. We give you a whole different planning section that gives you a whole bunch of different strategies of ways that you can manage life in the public and in the private, and how you move and safeguard all of that into the private realm. It's a lot to learn in there, and it's actually not hard. It's just hard because we haven't been shown it. But when you go through it, it's amazing how you retain the information and how sensible it is when you take the time to learn it.
I think it really is the deconditioning parts that are hard. Like, all this sounds hard when you're having to completely flip your paradigm in your head and deprogram yourself from all of the nonsense that you've been told to believe. That's the hard part. Because like this now for me all makes so much sense. It's like, yeah, that's like very easy to understand at this point. But I've also been loosely studying this for 4 years now, and you guys much longer than me. So for you, I bet it's like literally
2008 wasn't yesterday.
Yeah.
And I want to speak to that for a minute. We detox from things in the system, all these artificial things. We need the detox. That's essentially what it is a detox from what we've been toxified by our system. And so we spoke to the fear already. We spoke to there's this deep programming going on. Oh no, I'm going to have to go to the principal's office and play along with the rules, that type of thing. Then we realize that, hey, if we don't consent to those rules, we don't, now we have to be in alignment with natural justice and rules, which is hurting people and their property. So that's not part of this, but all these other things, like, I didn't enroll in the school, so why do I have to go to the principal's office? I'm just breaking it down to simple terms.
And that's the essence of equity, right? Yeah.
And all of what we're talking about, all of what that's what about being self-governing. And I heard limited liability come up with the LLCO. They can't sue me. Well, equity, and I'll get to this in a minute. I'll talk more, but full responsibility is where self-governance lives. If we're claiming limited liability, that's a contractual benefit with a public entity, which now there's obligations in there too. So full responsibility is the way to self-govern.
Can I use an analogy real quick? It's like the national status passport and the status correction process is you're getting out of the school, and equity is you saying like, look, your rules don't apply to me. Whereas a lot of other people are like, look, I'm going to go back into your school and try to point all the reasons why I don't have to come to your school. Equity is like, look, dude, like, I'm not in your school. Is that a good analogy? I don't know.
Well, this is the way we would say, I'm unaware of any contract that would obligate me to perform. If you present the contract for my examination, I'll obey it to the letter of the law. And there's a remedy in that too. So that's an honorable thing to inquire into. It's very equitable. Where's the contract? And that's the root we're talking about.
Got it.
Well, even if there is a contract, right?
That's what I'm saying. Obey to the letter of law. We have remedy in that in equity.
Yeah.
So, but please present it to me, because they hide these contracts unless you ask for them. But when someone's obligating you to a contractual obligation and you inquire to see the contract, they have to present it to you. If they're hiding it and you don't ask about it, then they just keep hiding it. Mm-hmm. But that's where inquiry, like I told you earlier, we got to ask those questions. So I'll pass it back over.
I love the power and the discussion of full responsibility, because that's a concept that most people just can't wrap their mind around. Because really, this is all about taking full responsibility for your life and not having an out, not having somebody step in as a patsy for you, or you're holding yourself into high account, and your responsibility is with source, right? Your relationship between yourself and source. That's a really powerful place to find yourself in, is full responsibility. And we'll pick that apart a lot more in equity in just a couple of minutes.
Amen. Wow. Well said. Hey, y'all, I'm here with Melissa Kupsch from Remedy Academy of Homeopathy. We are so stoked here at The Way Forward to be partnering with Melissa and Remedy in order to spread the message of homeopathy across the world, and also to partner on the eventual development of healing centers across the United States.
People are pretty quickly coming to realize that frequency is the future of medicine. We are witnessing the great resurgence of homeopathy right now. We're really moving away from that suppressive medical model, whether it's for eczema, asthma, hormones, fertility, anxiety, depression, trauma, whatever it is, it all starts as energy in the person's field first. If we change our field, we can completely change our life. Our 2-year academy is open worldwide to anyone who wants to become a homeopath. We've got 5 lecturers and we currently have over 500 students enrolled, which is record numbers in our field. A career in homeopathy is amazing for anyone who wants flexibility in their work and who wants to be valuable in creating this new world. We have stay-at-home parents enrolled, we have ex-medical professionals, grandparents signed up who want to learn how to heal their grandchildren and pass on that invaluable knowledge. We even have husband and wife teams. So my husband enrolled in the course with no prior knowledge of health as a background, and he is loving it.
Kylie is also enrolled as well, so my partner is, and she's so stoked to become a homeopath and to be helping to spread this message across the world.
The thing that we hear from so many of our students is, I found my thing. Homeopathy is the key. We harness frequencies from nature and we alter the field of all creations. So if anybody wants to join us or they want to know more about it, they can visit our website.
Yeah, and all that information will be in the show notes. So if you want to learn more about Remedy Academy, also Remedy Collective, also some of the homeopathic products that they have, please just head to the show notes. All of that will be listed there. Do you think it's a good time to jump into equity now?
We have the land, Allodial.
Yeah, so Allodial land. So we just briefly talk about. So I just went over the Trifecta, which is where you can build your financial life and your asset life and protect it into the private and learn how to navigate in the public with a lot more power and awareness. And then there's Allodial land, which Allodial land, it's when you find your way to being a freeholder of your land without encumbrances. So what is an encumbrance? A taxation, some kind of a contract, a mortgage, whatever the case is, that there's an encumbrance on that land. So when you find yourself away from that, you are truly in what's called Allodial land. You're just a freeholder and you have full responsibility and stewardship of that property. Within that is land patents. You probably have heard land patents. It's a big buzzword now. People are talking about land patents, but there's a lot of confusion about them. So land patents were, and I'm just going to do a brief overview here. Land patents were put into place during the Paris Peace Treaty before the Revolutionary War was completed. It was actually in discussion. It was part of the completion and the negotiations to end the war. And in essence, without going too deep down the rabbit hole, the crown, that didn't have any right to hold the land anyway, gave the land to the American people, and they put it into the trust, which was the United States government, right? And it was to be granted to the people that claimed it. So what does that mean? You remember the old pioneer stories where they went out west and they staked their claim? Well, those were land patents or paper patents. They weren't sold, they were claimed. So the only expense they had, because some people will argue, oh, well, they bought it. There's proof here that they spent their $3.50 buying the land. Well, that was them recording it in the county recorder's office. So there was never ever to be a purchase. The forefathers knew that if you found your way, especially your land, to be a sovereign is to hold land as a freeholder. And what can take that away, what can steal that away in the sneakiest ways is commerce, the banking system. So let's keep this out of their craw. Let's keep it out of their hands. So it was always designed to be given to the people that claimed it and took responsibility for that land. Now, treaty law in the Constitution, again, the highest law of the land, the Supremacy Clause says that treaties are the highest law of the land. That was a treaty. It's the highest law of land. It's still applicable today. So we've got these patents that were broken up into sections. Over a period of time, they broke it up into 160-acre meets and bounds sections, and your piece of that meets and bounds is somewhere in that 160-acre plot, unless you have thousands of acres that you own, right? So there's a process you can go through where you can claim or perfect your land patent. We call it pull the patent forward from history, that dormant patent that's been lying there for hundreds or 100 and something years. And you're activating it again. You're bringing it forward, and then you now bring that to the county recorder's office, and you perfect that. And then
is it pretty hard to go back and find that?
It's actually quite easy.
Really?
Yeah. The most challenging part is just organizing it in a way where you know how to start taking action. But we have a really clear and clean process for people to take action. That it's very easy, very practical, and we very seldom run into issues. And even going to the county recorder's office, there are some counties are a little bit more challenging than others, even allowing you to record those things. But it's their obligation to record. That's their job. And we have lots of ways to help people get things recorded without much huff or fuff whatsoever. And then the next part is, so some people say, great, well, you can get your land patent, and then what happens if the county sends you another tax bill? Because our land, just like our income, our right to earn money without encumbrances, we have a right to hold land without encumbrances. That's constitutionally protected. So how is it that the county can send you all these bills every year? Well, you've got bonds. So we step back to 1933 when they did the old switcheroo. They did this. They did a leverage against our future labor and our private and public property, right? So that's our bonds. They created these bonds against the deeds that are the title to our land. So every year when you get those tax bills, you're actually just paying the interest on those loans that the bureaucrats put against your deeds, right? And they don't ever tell you about the principal. So there's a way that you can actually learn about what the actual full principle is, and you can discharge that obligation. And now there's no impetus for the county to send you, right? So there's that. There's all kinds of remedies. And there's another process where you can do a writ of mandate, which basically forces the courts to acknowledge that the county never had any authority to tax or regulate the land patent. And then it forces an injunction, which makes the courts tell the county that you take no action against this patent, right? These are really simple things to learn. It sounds complex, but if you just take the time to learn, they're freaking powerful. Now you're holding your land. The county can't come in and tell you what to do, when to do, and how to do it, and they can't tax you. It was never constitutional. Important stuff to learn. You're building true legacy here. You're self-governing your life. So that's allodial land. And then the fourth one is equity, which Phil is going to explain equity. I like to explain equity as the great equalizer of anything that's unconstitutional. It's just my way of saying it. So if you find yourself into a contract where I was saying earlier, they say the contract states you have to give us all your wealth. Well, you can step up and say, well, that's a stomp on my unalienable right to earn a living without encumbrances. So you express equity to bring that inequity into balance. Right? So that's why I call it the great equalizer. And it made perfect sense to bring that in as kind of like the last powerful foundational piece or encompassing remedy piece of the foundation for self-governance. So now you can mop it up with equity, baby.
I love that so much because I've come to adopt what's called the neti principle, which is a method of self-realization through falsification. So not this, not that. And it requires that you are curious and asking questions in order to falsify things, right?
Yes.
So that's why equity, when I first learned about it, heard about it, I was like, oh my gosh, this makes so much sense. Rather than, making assertions and trying to tell people, this is who I truly am. All your codes, acts, and statutes say this. You need to acknowledge those. It's like you ask them the questions. Like the powerful, what's that quote? It's like the one who's in a position of power, this is paraphrased. One who's in a position of power is the one that asks the questions.
Yeah, ask king, the etymology as king. Okay, so the king asks questions. So when you're the one asking the questions, some of you have probably heard an authority figure say, I'm the one asking questions here, so who can be on their line of questioning better? And that's one of the components of it. But there's also principles and that back this up. There's a maxim that says, he who makes the claim must bear the burden of proof. Mm-hmm. It's a maxim of evidence. So the one making the claim has to bear the burden of proof. And if you're inquiring, an inquiry is in essence a charge on the person to form a reasonable investigation. And we're going back to that other maxim, all the dots connect. So that's at the foundation of it. Then I'll talk about the three main tools that we use in equity in a minute. But I want to share an analogy about the Foundation for Self-Governance that I've kind of been formulating. It's fun. I talked about the HOA association. So let's say we used to have a allodial land title, right? And we had this private land, and then we built our private house on it in trust, right? With fire-resistant materials, and we built this structure on top of it. And then we wanted somebody to protect that and manage some of the affairs of the community and things like that. So the HOA was formed, and like most HOAs, they kept increasing their power. And then it got to the point contractually where they made a claim on that private land, and they laid a homeowners association title over, and they laid claim on those things. Well, the Foundation for Self-Governance is taking it back. The National Status Passport is, you don't need an HOA identification, and you don't identify with the HOA, so you're private on the land, right? The trust, this is a private structure that can't be pierced. We don't need you in our contracts, because most people form a family trust, and it's written by an attorney, and it's certified in the public system. It's open book. They can look at everybody in there, who the beneficiaries are, the entire thing. And no, that's not the way this works. It's private. Nobody gets to look at that unless you're involved in that private contract. And then the land, taking that back and for the allodial land title. Now, equity is the great equalizer, as Michael's saying. So if a fire starts with the HOA, or, there's a fire threatening your affairs, or a challenge to that, you get to take out the fire hose and put out the fire, is what you get to do. And it equalizes those inequities in the system. So whenever there's an inequity, we just need to look at that. And one of the maxims of equity is equity will not suffer a wrong without a remedy. One of the synonyms of equity is remedial justice. Another synonym of equity is natural justice. Okay, I'm starting to like the sound of this. I don't know about you. Okay, so when we embody equity, it's one of the 3 jurisdictions mentioned in Article 3, Section 2, Clause 1 of the United States Constitution: law and equity, and admiralty maritime. So we know those are the 3 that we're dealing with. Now, legal is admiralty maritime. It's commerce and contracts, international trade. That's the form of the HOA. Now we have law and equity over here. Law is common law, which common law was the procedure, was the contract, those type of things. Well, equity is the equalizer. It's the supervisor of all of them. And so it has the ultimate say over contracts. So if we're in a system of commerce and contracts, why wouldn't we want to access the natural justice that's available to us that is focused on remedy in every situation? So that being said, that's my little analogy there. Now, equity may be new to some of you, and I understand that. It's something that you're probably going to hear more about in the future. I'll tell you that. It's been around longer than the other forms of jurisdiction that I mentioned as well.
Is that why it supersedes them?
Yes, it's natural justice from the creator for private individuals.
Because it's right in line with natural law, essentially, is what we're talking about.
It is. And the other ones are fictional by definition. Enactments, statutes, dictates, mandates. Those are from earthly authority. Those are from man. This equity is the principles of how men and women should be treating each other. And they go back to every religious text in history. That's where the wisdom commands of how to be a equitable human being come from. So that the maxims were extracted from those wisdom commands, and I already mentioned about maxims. Those are the foundation of the whole entire justice system. Those are settled, universally approved. They are not up for debate. And so when it's a maxim, we can inequities are in conflict with the maxims and the guiding principles. And so that's the important thing. Inequity is not written down. It's the unwritten law. However, the principles are written down to read. They call it the unwritten law because it's not strictly written. There's no statutes or codes governing it. We need to look at the principles on what's fair and equitable in the situation. But also because the ones in power have to uphold natural justice, and they do this not for our benefit. Don't think that maybe for 1 second. They do it because they want to live under natural justice. And so if they do away with it, then guess what? They don't get to run around and do whatever they want and be private and everything like that either. So it's also, in a way, no one wants to be in misalignment with natural justice because the law of nature has its order.
It does. It's powerful.
Yeah.
It's
and
uncanny.
that's precisely why, I'm sure they rack up some karmic debt for this too,
Right.
but that's precisely why they offer us contracts rather than actually forcing us. And again, that's not an exclusive statement.
Yes,
It's
true.
not purely black and white, but largely, if you look at what happened during COVID, and that's why I threw up a lot of air quotes at the beginning when we opened up, it's like, they didn't actually force us to do anything. They didn't force us to do anything.
Right. There was coercion.
There was coercion for sure, but
yeah.
they didn't force us to do anything. They were coercing us to contract
Yep.
in a variety of ways.
Yeah.
Or
Yeah.
if you already were in a contract, such as a business, they have full authority over that.
Yep, exactly.
Yeah.
Exactly.
And then you didn't see the state enforcing with their own employees and things that people were contracted. They did, but It just like most things, it's kind of like a hall monitor at the school. Let's go back to that analogy. You have these people that stick up for the system, like the employers that want to enforce that suggestion, and then they do the dirty work, and hand out those tickets in the hallway and all that kind of stuff. I mean, that's what's really going on. But again, if you're employed, I mean, I hate to say it, but you are contracted into the public. Now, there's ways to maintain your privacy in that situation. You don't have any options, but you are subject to certain other elements that you aren't if you figure out how to restructure. But that's a process for everybody, and that's another conversation. Back to equity. Equity, one of the main things about equity is it wants to make all parties whole in the situation. Now, that's important, because if not all parties are made whole, equity wasn't carried out, and that means there's still a controversy, which means that's why some of these other remedies, not to put anything down, but when you're arguing about laws and things like that, you're not handling the underlying financial banking aspects of the matter and extinguishing the contract. And in the scriptures, the wisdom commands in Matthew 5:25 and 26 state, settle, and I'm paraphrasing, depending on what version you're using, that settle with thy adversary on the way to court, or else you'll be handed over to the officer and you'll be thrown in jail until you pay every last penny. They're telling us to settle with our adversary. So in this post-1933 system, I already talked about it earlier, about how they charge the citizens, and they're the ones and liable, and then the surety is and we were joking about this last night, Daniel and I, piece of surety, POS, it gives it a different term. I'm a piece of surety, okay?
That's good.
So if you're surety, then they're going to come after you and throw your corpus in jail, or come after you, and you're going to be discharging, just like Matthew 5:25 and 26 said. So why not just settle and make them whole? Why not just give up the argument and say, oh, if you'd please present me the liability and let me examine it, I'll honor it immediately. How good would it feel to say that? So this is about going to peace in the system. It's not about fighting. It's not about arguing. You can give all that up. I'll just tell you a personal story. When I was in my 20s and I was first introduced to equity in 2008, I was angry. I found out about the Federal Reserve. I found out about the money. I started all these things. I was aware. I could see things, and I was in an angstful place. And I was writing letters to people and doing all the stuff that people do. And it was coming from a place of just wanting something better, knowing there was something better. And when I was introduced to equity, it's felt so good to just let all that dissolve and go to peace over. And then now the life path and journey has led to empowering others to do the same, to just let that stuff go. It's not, your blood pressure, your cortisol, all that stuff. And are you really making a change, or are you falling into a common trap designed to ensnare you even deeper? Because now it's not only taking your physical world, it's taking your emotional and spiritual world along with it. And so that's why this is very much a life-changing knowledge, and it's applied very simply in many ways. Again, we have a duty to inquire, and when we inquire into one making a claim, and I want to be clear also, equity is the best defense that's been ever created. It's not a way to go into their system and fight them, because that's contrary to the way things are designed, and that's another topic too. It's a way to be left alone. And if we look in Black's Law Dictionary 6th edition under privacy right of, paraphrasing, it says that if the public attempts to concern itself in your private affairs, it says equity will interfere. So
says that in Black's Law.
It says it in Black's Law Dictionary. And we're told that equity is the way to be protected in the private and be left alone by the public. And it's very clear about that. And the reason being is they have no business in our private affairs if we keep them in the private. Now that's a choice. And if our conduct and concerns the public, then they are going to come in and do the public thing, as we've been talking about. However, when we know how to manage ourselves and our affairs correctly, there's no power in it for them, and we can go to peace and be left alone. Because that's the number one line in privacy right of is the right to be let alone. Mm-hmm. Okay, so I think most of us, if we're angry by the system, and it's hard not to be, honestly, with a lot of things that are going on, but if we have another option available to us where we can decide to leave and be left alone by it, then that creates a greater sense of peace, and it changes, not only will we be healthier mentally, physically, and spiritually, but we'll also have that confidence, like you were mentioning earlier, Alec. If anything comes in the mailbox or anybody, tries to engage with you, you have the tools to settle that and be left alone and not consent and not be dishonorable either and not have to argue or fight and struggle. So there's talking about the money change. They wrote into the public policy this remedy in equity. You can look in Black's Law Dictionary, 6th edition, look under discharge, and you'll find a subheading that says in equity practice.
Mm-hmm.
So there's equity discharge, and it's written into the law, and it was put in there because they know that we're the substance in the system. There's no gold and silver.
They know that there's no real money, so they have to provide remedy.
They have to provide, because they didn't amend Article 1, Section 10 that laid gold and silver out as the tender.
Mm-hmm.
So that's treason again if you don't make a remedy. So there has to be a remedy. So they wrote it in. So this post-1933 equity is called concurrent equity. It's malleable and it adapts to the surroundings. Where, if anyone's ever heard of the term exclusive equity, that's a bit more rooted in trust law. It's very valuable information, but it's pre-1933 and doesn't provide this malleable discharge remedy. So that's the first main tool that equity brings for us. The post-1933 is equity discharge, which means that we apply private substance to the public ledger or the bookkeeping, and it zeroes out the account. And it doesn't have to come out of your wallet that you're carrying in your pocket. It doesn't come out of your bank account. So it's all credit, and it's a way built into the system where that just goes away. And then that's first tool that's applicable, and that also applies to contract offers. So if somebody's offering you something, I used the example earlier about a 1040 form with the IRS. If you don't volunteer for that, and we were talking about the perception of, there's people in jail for that and stuff like that, of tax evasion or willful failure to file. Well, that happens through other subcontracts. I won't go into that too much, but even if you don't volunteer, well, most likely you'll receive something in the mail, an offer that says, well, our records indicate that you didn't file for tax year, blah, blah, blah. If you understand what that actually is and that that's a negotiable instrument and that's an offer to contract. Yeah. If you don't understand that and you throw that away or you don't answer, you dishonor it. If you fall in the dishonor under the UCC, then you are cooked. Okay, that's what happens.
To use a Gen Z term, you're cooked.
You're cooked. I'll just say this: they are building a record against you, but you have the power to honor that inequity and build a record of honor that will cancel out any actions that are being taken. So that's also included in equity discharge. It's a way to honor contract offers without consenting.
Mm-hmm.
Powerful. And you can use that anywhere. That's just not in that example I'm talking about. Anything, the selective service draft. It's even called a draft. It's a banking term. It's a bill of exchange. Like if you don't settle that instrument, then you get to go serve the discharge. They even call it discharging you, honorable discharge when you get out. You have to pay it off by serving. Or
I had a medical discharge from the Army, so I know.
It's
literally called discharge.
Yeah, there you go. So it got discharged. The banking was discharged, and you're contractually their property along the way too. Now you can go sit in the county or state hotel if you want to and discharge it that way, or you can sit at home and discharge it with equity and not have to do anything else.
Mm-hmm.
So so we have choices, but the way the power structure works, just like the principal's office, is they limit your options. And all of you that have kids out there, if you go to a restaurant, you probably tell your child you can have this or this. You limit their options, even though there's other things on the menu. And that's just the way it works. We direct people where we want them to go.
It's a hidden menu.
Yeah, hidden menu. So exactly. So that's tool number one. That's really applicable. And there's more tools in this, but these are the main ones. The second one is dissolution of public contracts and releasing your obligation in those. And it's all done honorably. And if you look at the definition of rescission in Black's Law Dictionary, the second paragraph says inequity practice. So we see equity again, and that's unmaking a contract from the beginning, not merely a termination. Public contracts, There's a lot of debate about how legitimate they are. We were talking about this, Alec, before the show. We don't argue the validity of it, but the system knows.
Right.
And so it's not equitable inherently, these public contracts. Now, private contracts, different deal, but we can remove our involvement in those and release that obligation. Now, we may still need to make the other party whole. We can't leave them high or dry, so we need to discharge the liabilities associated, use tool one and tool 1 and 2 together, and that settles the matter there. So that can get you, I think most of us have seen one of those movies where someone signs a contract with a very unscrupulous spiritual being or someone, and then they go through all these trials and tribulations and all this, and at the end of the movie they repent and acknowledge their mistake and change their ways, and all of a sudden, the sun comes up and the flowers bloom and everything's okay. Well, that's showing us a principle in law which is based on the wisdom command of repentance. So it means that we acknowledge, but we have to change our conduct in order to fully repent, and we're to be forgiven when we fully repent, and that's one of the principles. So that transcends through into the system. And tool number 3, we've talked about it several times, which is the art of inquiry. That's inquiring into those doubtful matters to discover what's truly lawful. And the one making the claim or having the charge against us, they need to answer those questions, or else, there's an issue there, and
they're not providing the proof. The burden of proof is on them.
Exactly.
Yeah.
And not only that, that's the way we peacefully compel performance of these officials and anyone we're dealing with, is because when we apply equity in the correct manner and we take the lawful stance, the inequities in the situation start revealing themselves, and they're undeniable. And when the record shows all of that, the record is what really matters. I talked earlier about, the file, the doctor's office. He's not going to refer you to someone up the chain unless it says that you need it in the in the file. The same goes for this as well. And we'll find our remedy when we ask the question, asking the questions that they either don't want to answer or they can't answer, because it'll reveal what they're actually doing, the presumption of authority and all those other things that their program that they're used to running.
The custom,
yeah. And thank you, Daniel, because custom is another sort of law. And so the way most of the systems running on customs these days, that's why it doesn't matter if there's fraud in the contract and all the points. Consent erases all defects. So if you consented to a fraudulent contract, that's going to be a very hard thing to prove and argue, because you consented to it, and even the threats, duress, coercion, force, and fear that people feel like they're pressured. If you consent under that, then you've also said it's all okay, it's all jiggy. Okay, and then that's one of the principles that we need to understand, is that if we did make a mistake and do that, we do have remedy and equity anyhow. So it's almost never too late to apply equity, and you can apply it to something 10 years old if you want to. If you figured out what to do now, equity time travels and goes back, and there's principles to back that up too.
That's such a tough point for me, though. Like, when I look at it from a strict philosophical lens, like, so many of the various quote unquote contracts that we've been, put into aren't actually meeting the elements of a contract.
Mm-hmm.
But at the same time, it's like, one, society and the prevailing system unanimously recognize them as legitimate.
Mm-hmm.
And then the second thing is, there's the difference between consent and assent, where you're still acting in the capacity of someone who has willfully entered into that contract. You're still assenting. You're acting as if you knew the tenets of the contract.
Well, so there's a big distinction there I'll get to in a second, but I want to talk about custom for a second. Custom is a sort of law through custom and usage that it actually supersedes common law. Well, there's a maxim that says custom supersedes common law.
Interesting.
Because if the population habitually consents to something over a given period of time, and they're doing it with the face scan at the airport right now, for instance, they let you opt out, but that sign will be gone eventually, because 99.9% of the people just walk up and consent to it. And so that's how customs are formed. We're seeing it before our eyes. When it becomes there's also a maxim that says custom is a sort of law. Okay, so it supersedes common law, and it's a sort of law. It doesn't say it supersedes equity. Okay, so they just program it, and people go along with it, and habitual consent creates custom, and then it's a sort of law, and they enforce it like that. And so the elements you're talking about with the contract, everyone's saying okay for decades and decades, and this is his normal business now. And oh, what? You guys are okay with it, so this is the way we can conduct our business now. Now, when you bring equity to the situation and start inquiring, record scratch, the party stops. Because we need to inquire into it. Are we inquiring into it? Or are we making a claim, this is fraudulent? And they're like, well, you consented to it.
Yeah.
So, and not only that, it's our custom and you consented to it. So, that's on you. And it doesn't say arguing gets you out of contracts. That's not in there anywhere.
Right.
Okay. So just think about those things. So that's where the reprogramming happens and the full self-responsibility. If we made the mistake, we're the one that can remedy it. It's not their fault. It's our fault. But we need to be real with ourselves and own our responsibility. That's where the remedy lives. The remedy lives in saying, oh, there's a bill, there's a liability. Well, please present it to me and I'll authorize the credit on it so you can settle out this account. I have the power to do that. I'm not going to point at you and say, I don't owe you the money. Because, in court, guilty means I owe the money I'm going to pay. Not guilty means I owe the money I'm not going to pay. And they took away innocent when the money changed because everyone's guilty and owes the money now. Okay. So there you go. That's how it works. So how about saying, oh, would you please have the plaintiff render the account and present it to me for my review and I'll honor it immediately? How about that? You show up like that, you get different results. Because stop thinking that you're the victim. Like we talked about victim state mentality. Once we give up the victimhood and we know and we learn that we're the one that has the authority and the power, then we're getting somewhere.
Right.
So the assent and consent. Assent is that's what royals do in Canada when a law is promulgated. It goes under royal assent. Okay. Assent is what royals do. They authorize something. They allow it. Okay. They're not consenting to anything. Okay. They're just saying, yeah, you can go do that. Okay. So, and consent says, yes, I'm consenting to all of the stipulations of this contract agreement and I'm subject to the obligations and I'm bound. They even use the word bound. Okay. So how do we get released? Well, the signature created the contract. The signature can also unmake the contract, and that's the maximum contract. So we just need to understand that process, which is an equity teaching, and then learn to assent, which means, oh, you're offering me a bill. Well, I'm not consenting to this, but I'm gonna authorize the credit, and because you offered it to me, you're contractually bound to carry out that. And I've tendered payment in quotes, and you can't require me to tender payment twice. So here you go. You have the credit to go settle it. Then why didn't you settle it? Oh, you're in dishonor now because you didn't settle your contract obligation. Okay. That saying on the playground, I am rubber, you are glue. Whatever you say bounces off me and sticks back to you. Yeah. That's exactly how it works, because the law of offer says the one making the offer, when it's accepted,
they're the accommodation party.
They are liable. So they can't get you without putting their neck on the line. And so when we understand this, then go ahead and make an offer. You're going to be liable to it. And you're going to become a debtor, and that's just the way it goes. So it's a totally different mind switch on how all this works. And it shows where the real power sits.
Full acceptance, full responsibility.
Yeah. And I like also how you use the Aikido metaphor.
Yeah.
How we take on their energy and just send it back to them.
Yeah. Peacefully.
What I love about this is everything you just said, first off, but like when something just rings true, at least for me, I can like feel it in my body. And when I hear this, it just rings true. I feel it in my body. I'm like, yes, this is true. This is the way to do things, right? Mm-hmm. And again, it's coming from stepping out of that victimhood mentality that even a lot of people in the freedom space, say that they don't actually have any power, but then they're obsessively talking about how powerful and how fraudulent the system is. And it's like, yeah, don't get me wrong, we should be aware of that, but you're giving it power by obsessively focusing on it and talking about it. Like when you understand this, all of that becomes noise. Mm-hmm. It just becomes noise. And it's like, oh, we literally are the true source of power, and we now have a way to exercise that. That's it.
That's it.
And then we can stand on that. We don't have to prove anything. We don't ask for permission. We don't ask for, their blessing or anything like that. In fact, plausible deniability that's stated in the letter from Edward Mandel House to Woodrow Wilson around the time of the formation of the Federal Reserve states that they're going to turn everybody into a pledge and use the birth certificate as a security. And if anyone figures it out, the 1 in a million figures it out, we have plausible deniability in our arsenal. And so we have to just count on that, where if you're going in there looking for a standing ovation or a pat on the back, you're not going to get it. So it's not about that. It's about standing in who you are and standing in that authority, that divine authority that we all have, and choosing to be on the private side of the mirror. I call it the looking glass. Fiction's through the looking glass, and they try to siphon that life force through. And, we can stand there and we actually even call it mirroring. In contract law, it's called mirroring. We mirror back the fiction to them and let them have the fiction back. We mirror it. It doesn't go through the mirror, is what I'm saying. And so I love analogies, as you can tell. It's really about owning your personal power, and equity was built as, we've all seen Lady Justice with the scales of justice, as Michael was alluding to. When something gets unbalanced, our remedy's provided in equity, and it creates it directly, of course, opposite the injustice in the fictional system. And if we don't understand that, then no one's going to teach that to us. Now, I just want to say more than 1 in a million. Well, hopefully more than 1 in a million is figuring this out.
A lot more now.
I think and that number is going to really increase, but that's what we're really here to, and invite everyone into leaving the fictional system, the homeowners association. Go back to the land. Go back to your private rights. Go back to having you and your family's affairs protected in the private, and have the fire hose equity to put out any fires or friction that starts up. Have the proper legal status designation to show who you are, so you can travel under the Bill of Rights and not be detained. Have your structures protected so that you control things but don't own them, and they're all private, and nobody can look at their private contract at all, and no one knows who the beneficiaries are. No one knows your business. That's private, and your contract protects you. And then have your private land that can't be taxed, can't be taken from you. And it stays in your family as long as you want it to stay in your family. And that's the point of the Foundation for Self-Governance, is to bring these elements in the private life back. And that's, again, we invite you to come into the private fellowship with us, and we'll be able to tell you much, much, much more about all of this. But here we can't solicit to the public because we're private. We can invite, and that's what we're here to do. And that's the main call to action here, is come on in. It's complimentary. The water's fine. You get to have more discussions with all of us. So that's what we're really here to talk about. And again, one of these pathways may have resonated with you more than others, and that's natural. And you can kind of feel it, like you said, Alec. You can feel when it's in your body and something lights you up. That's the divine in us, reflecting and awakening. And so, we're here for all of these, and they're all intended to bring you into that private place.
Well said.
He mopped it up, like I said.
I mean,
let equity mop it up.
I've said well said so many times during this episode, because I'm like, damn, I don't have anything to add. Most healthcare today operates on an outdated mechanistic model, treating the body like a battlefield rather than a self-healing system. You wait months for an appointment only to receive a rush diagnosis that labels you rather than truly understanding your unique health. Even in holistic health, many practitioners rely on endless lab tests and supplement protocols, addressing symptoms instead of the root cause. And the result? Another prescription or supplement regimen that merely suppresses or masks symptoms rather than facilitating true healing, whether the imbalance was physical, emotional, energetic, or a mix of all three. And that's why Dr. Tom Cowan co-founded the New Biology Clinic, to offer something radically different. As one of the most respected natural health doctors in the world, Dr. Cowan has spent decades challenging conventional medicine and advancing a deeper understanding of human biology, water, and natural health. His work isn't just about rejecting the mainstream. It's about offering a more truthful, biologically coherent approach for healing. The New Biology Clinic recognizes that health isn't about fighting disease, it's about restoring balance. You're not a diagnosis, you're an individual with a unique story, and healing should honor that. With virtual consultations available worldwide, the clinic offers a flat-rate monthly membership that gives you direct access to practitioners who take the time to actually listen. Members also get exclusive health live streams, a resource library, and live sessions covering everything from biofield tuning and breathwork to movement and meditation, all designed to support whole body healing. And if you're not ready for a membership, you can book a one-time appointment, sign up for an enrichment-only membership for the healing modalities alone, or schedule a free connection session with one of the care team members to see how the New Biology Clinic can help in your specific situation. This isn't about keeping you dependent on doctors. It's about making you sovereign over your health. Head to newbiologyclinic.com and use code THEWAYFORWARD, and that's spelled The Way, FORWARD, for $50 off account activation, or just head to the show notes for more info. If you're a member of The Way Forward, email hello@thewayforward.com for $150 off. Your body already knows how to heal, and New Biology Clinic helps you remember. The unsecuritized versus securitized debt as it pertains to discharge. I know I mentioned that earlier, so if we could just discuss that a little bit, because there's a lot of conflicting ideas on that as well.
Yeah, that's a great question, a common one. Now, the difference is in the contract. So when we agree to a contract, there are obligations. So if there is collateral that's contractually added into stipulation in the contract, then you can expect the customs we talked about and the program of the system. You can expect them to enforce that contract because it's explicit and expressed. You can count on them to come and collect that collateral. Now, in the end, at the end of the process, I want to be clear about this too. Equity is a process. It's not a magic wand or a silver bullet, but it is a universal and complete remedy. Now, you have to walk that out, and as more and more of us wake up in the system, that process will get refined because the other side has an obligation, but they can have more bandwidth to test as things move along in some aspects. So that being said, a secured loan like a vehicle, for instance, or a mortgage or something like that. Well, that's big business for these parties that have a financial interest in those, like mortgage-backed securities are sold on the financial market, for instance. There's parties that have financial interests. We don't even know who those people are around the world, potentially. So all those parties have to be made whole. I want to be clear about that. That's a principle and a tenet of equity. So equity will make them whole, but it will be a process to carry that out in most cases. And in the interim, there may be some attempts to collect, or there most likely will be attempts to collect that collateral. So it's more dynamic. Equity will do what it says it'll do. However, secured situations are a little more dynamic. Or if it's a vehicle, for instance, you might have to lock that vehicle in a private location until discharge is complete so that it can't be, because possession's 9/10 of the law. If they come and pick that vehicle up, you're not getting it back. Okay. But if you hold on, equitable title of that vehicle means it's in your possession. So if you have that secured, then you can discharge the liability, settle the contracts and all of those type of things, and then be released from that. So that's how that works. Unsecured, there's nothing for them to take. So we get to give them the credit authorizations and let them settle the accounts. Very clean. In fact, I recommend to everybody to, start small, where your posture, process, and pace, the 3 Ps they're called, start small and work your way up, because you don't want to bite off a bunch of big things you can't, and stress yourself out and not be ready. Because again, this is a system of justice. It is simplistic. That's one thing I like to talk about real quick too, is that you don't have to go to years of law school to learn this. You don't have to learn the statutes and codes. You don't have to, all those formalities and things like that. This is rooted in natural justice and principle. And once you learn how to embody the principle in the energy field, which again is an inner peace, outer confidence, and a genuine inquisitiveness, that's the energy field of equity. And once you embody that, you can apply a universal process that's actually designed into the commercial system for this purpose. And you apply that to your matters. Now, there are nuances like secured or unsecured, or court or not court, or, things like that. But the overall baseline is fundamental. And you just have to work your way into comfortability. And a lot of it, because of the plausible deniability, a lot of it has to do with your inner stance and belief too. So learning the process, which is studying at first, trusting the process, which is trusting what you've learned, and then walking the process out to completion. And a process isn't done until it's over, okay? No matter when we want it to be over, we got to walk it out. Once we walk out the process, that will increase our trust in the process even more with our real life experience. And that's what builds on each other, because we're in the face of this plausible deniability and this, I call it an abusive relationship with the fictional system. It's gaslighting. It's, manipulation. It's all kinds of stuff going on. We have to, just like anyone who's been in one of those relationships, you need to wake up and you need to process all that and you need to move on. And so plausible deniability is going to make you question yourself. However, with the way we instruct in the intuitive process of learning this, you can rest assured that you're gonna have the tools to proceed and in the face of the plausible deniability.
Well, I wanted to talk about that equity is a private remedy, and it doesn't express itself in the public, and there's no litigation. There's no litigation required for this, right? There's no arguing.
That's a really important point. Very important.
You want to talk about that for a moment and talk about the distinction between the public and the private, because a lot of people might ask, well, I'd like to see the court cases that prove this. But there will be no court cases that prove it, because discharge is generic. It doesn't express itself as discharge. It expresses itself as some kind of statutory release of some form, because that's the only language the public can speak. It's hard for people to grok this, especially when they're getting into the deeper realms of living life in a peaceable, non-controversial fashion, which is everything that we express. But pick that apart.
Yes, absolutely. So when it comes to public versus private, the public, as I mentioned before, can't involve itself in private affairs. So if the public speaks about something openly, it's not private any longer. So it crosses the line, essentially. So what we do is in equity is a private discharge. The public version of that would be a bankruptcy, where it's a contracted public discharge and appointing a judge to administer that, contractually based, and that is in the public. So it'll stay on your record for 10 years. There'll be all kinds of other contractual repercussions, plus you're subject to what the judge wants to do in the situation. You have the ability to do that and administer your own affairs without contracting and delegating those. So as far as case law goes, equity is built on principles, and it's also built into the law to provide remedy. So it's already in the law. We don't need case studies to back it up. It's written in there. We just follow it to the letter of the law. Case studies are more for admiralty, maritime, and common law. The strict written law comes up with precedents. That's one of the forms that it operates through. And I said form, catch the word form. We don't need form because we have substance.
Right.
And substance is greater than form. When we bring our substance to a situation, it's banking. When we settle the accounts and the banking and the charges, the natural reaction to a charge is a discharge. I talked about the light bulb earlier. When the electricity travels through and it hits the light bulb, it discharges and lights up. Well, that's what a discharge may look like in that instance, but it can look like, as Michael mentioned, it's generic. So the way I say this is it's a generic term, discharge. It can take many forms. In court, they call it dismissed for some, that's a synonym of discharge, but they rarely mention that word in some instances because it's shrouded. Alec, like you said, is a medical discharge from the military, or when someone gets out of jail, it's discharge. President Trump in New York, 32 felony charges and guilty of at a jury trial. Guess what? Unconditional discharge at sentencing. Okay. You want to see equity.
You don't see that publicly very often. That's the first time I've ever seen it like that.
I've seen some paperwork of elites using that being quoted as using the equity maxims and things like that, and the case goes nowhere. But that was the biggest instance, I think, in recent. You want to see a case study? Look up the unconditional discharge at sentencing with 32 felony convictions. Okay. There was no charge left anymore. The charge had been discharged. And,
so you think Trump really understands equity then?
Of course.
It would be hard to imagine he does.
Or at least someone close to him understands.
They have private lawyers, and they no doubt use it. And there was also a case back in, I think it had to do with election fraud after the Biden election. Someone was suing for election fraud, and he quoted in the Supreme Court filing that they were using equity maxims the elites. There's 300 elites and politicians that were on the docket. So it's in there. And
Wow.
I just want to say it just like the Federal Reserve can't be audited because it's a private trust. You can't talk about private things. You can't dip in the private books. They're not going to talk about this in the open because the whole thing will fall apart, and you're not going to get, again, plausible deniability. I said 1 in a million figures it out. We have plausible deniability to take it out, and that's what the system has told us they will do. We need to believe them for what they say in that instance. We can't believe them all the time, but we need to believe that because it's in front of our face.
Yeah, so I want to just talk for a moment about plausible deniability, because you've mentioned it a lot, and I don't know if people really understand. It actually took me a minute to figure out what it was some years ago. But plausible deniability is just a way for somebody to get out of something that they've done wrong, essentially, for instance, the 501c3 is a direct insult to the Establishment Clause. It's the direct insult for somebody to be able to have their own religious expression without encumbrances. So when you sign the contract of a 501c3, you're basically getting permission from the state to exist, and you get a benefit of being tax exempt, but you have to completely give them all open access to your books. You got to file, you got to record, you got to be totally open with everything that you do. It's a public matter. It's not a private matter. You're considered a public entity, not a private entity. So if you're a religious establishment, if you're expressing yourself in some philosophical or religious fashion, well, that's a direct slap in your face of the Establishment Clause. So if people have challenged it, they said, hey, this 501c3 thing, it's a direct insult to us. And then they go, well, there's this 508c1a thing over here. I'm sorry you didn't know about it. Not our problem. Right? So what is the 508c1a? Well, if you look it up, it's one of their statutes and codes. It's a man-made code, but it's their plausible deniability out of their treason of entrapping somebody to give away their religious rights to a corporate state. So a 508c1a is mandatorily exceptions for everything of the 501c3. So it says if you're a church, an integrated auxiliary, an association of a church, you're mandatorily accepted from the rules of the 501c3. That's their plausible deniability out of the treason or the fraud of the 501c3. So that's what Phil is talking about. They're full of all these plausible deniability shenanigans. And really what we've done a lot of is we've kind of followed and tracked all those plausible deniabilities, and those are basically the remedies for people.
Yeah, same with the national status. The remedy, the plausible deniability for the U.S. citizen is the national, the state citizen, right? And one thing I wanted to add also, when we bring these remedies to the table or to a matter, when the discharge completes or when we stand on our national status, again, they're not going to give us a certificate of accomplishment or something like that, right?
Yeah.
It's just going to go silent. It's just going to disappear, and it's just gone. It just stops, right? And that's unfortunately the best evidence that we have. People ask me, well, show me this is real, show me the evidence, blah, blah, blah. I can show you the codes and stuff, but show me this works in the courts. Now, of course, for the national status, we have lots of court precedent all throughout the last century. The courts have been telling us, there are these two statuses, guys. But when we bring remedy to a tax situation, for example, it just stops. It just goes away.
That's a great question, actually, is the success rates of let's say the unsecuritized stuff, because that's a little bit easier. Like, what is your success rate with that, with people who are members and have learned from you?
Yeah, if they are committed to walking it out and face their doubts in the process, trust the knowledge that they've learned, it works every time. It's written in the law.
Yeah.
So it's not a fact of if it'll work, it's when the process will conclude. And oftentimes it's a step or two before it's complete that people get very weary, and I've seen that. But it's like, hey, just press on a few more steps, and they do it, and then it goes silent, or they get a letter from taxing agency that says no further action needed on this account. But the 10 months earlier, they were, wanted to have them in for an in-person meeting type of thing.
Yeah.
And now 10 months later, no further action needed on this account.
Wild.
So it's just, again, that's why the process, posture, and pace is important. To know what you can bite off, to know where you're at internally, to know how capable you are to apply the process and walk it out. And that's why it's an ongoing thing. We don't just, we're in fellowship here. We don't just drop you off at the bus stop and say, have a nice trip. The fellowship is about fellowship first and foremost. And so this is for people to not only be exposed to this type of stuff, but to soak it in and then to walk it out.
Yeah.
And I want to bring
Full
up,
embodiment.
yeah, exactly. And I want to bring up the litigation. I didn't get to that one, so I got to ping
pick
pong
apart
back
that.
so we don't. One of our creeds is we do not argue the facts, jurisdiction, law, or venue. There's no reason to argue any of that stuff because it's all about the banking. So when you go in there, you don't have to litigate when you go into a situation where let's say there's bar attorneys and a banker on the bench. Okay, and I say banker because if you look at the definition of bench, it says the bank is the first entry in Black's Law Dictionary, and then the second entry is the seat that justice is administered. Okay, so they're telling us that it's a banker first and foremost, and a judge secondarily. Wise. So if that individual is more concerned about the banking, and we're going in there settling the banking in the matter, which court service, a synonym of court service is court process. A synonym of court process is negotiable instruments. Okay, so it's just a banking, and we know what it is. And so when you go in there and you apply equity, there's no need to argue about anything. In fact, I'm not here to testify. How do I settle this today? It's all about settlement because Matthew 5:25 and 26, if you don't settle that debt, guess what? You will be going and paying every penny. So it's all about settlement. So we don't argue anything. All we do is inquire into the record, and the record states that the matter is settled. And if it's not settled yet, then please provide me with the account statement so that I can settle it for you. And then what it turns into is the other side's dishonor. If they're still holding you there and the matter is settled, then you get to enforce the contracts on them and their dishonor. So it goes, like I said, I am rubber, you are glue. This bounces on me and sticks back to you. So we don't litigate anything. We don't argue anything. We don't talk about the law. We don't teach them the law. We don't ask about the law. We're there for banking purposes only. In fact, that's one of the things with trusts, or churches, if you check banking purposes only, they don't, you're in a different category. So we're there for banking purposes only. Yeah. we're not there for the controversy.
Right? Just like stop and take it in for a moment, because that's really what it is. And all we're sharing with people is the position that you're in and how you can walk in that position with a lot of power. Ultimately, all we want to do is be left alone. So you can go in with that point of power and you can settle the affair, you can settle the matter without controversy, without arguing, and doing it in a peaceable way. And again, what most of us want is to be left alone. I say that because some people are in their trauma reactions and they want to argue and they want to fight, and a lot of people are still there, and bless them.
They want to, quote, expose the system and use all their
energy. They want
to
fight and argue.
Yep.
And bless them. Hopefully they'll work their way through that. I can't say I haven't been there.
Right.
I've been there before.
Been there, absolutely.
Yeah,
my heart was enraged for years, and I had to walk away from this until I found my center and went on my spiritual journey. And then I circled back around on all this stuff, and I had a different place with it, right? So the foundation for self-governance is all about being left alone, about building your life in the private where you can be left alone. And if you have any matters that are still outstanding in the public, you put on your bookkeeping hat, you get into the public, or you stand into the public, and you settle and close the matter, and then you come peaceably back into the private. And after a while, when you keep expressing that and you keep learning, you keep building your life in the private, you will be left alone, and you won't have to express equity. You only do it when you need it, but sometimes you got to step in there and clean up your affairs that you already have out there. Mm-hmm. So just do it. Clean up your affairs while you're building a life in the private, and then peaceably go into the private life.
And I want to be clear too, because there's processes out there that want to go into the public and treat it like their personal bank account and things like that.
Yeah.
That is not built into equity. That's not the purpose of it. It's about ethics, and it's about making all parties whole, and it's morally centric. The legal system lacks ethics, lacks moral permissibility. It says it right in the law dictionary. I'm not making it up. Okay. So in order to receive equity, we must embody equity. The one seeking equity must come with clean hands. We need to demonstrate it in our conduct. If we're showing up as going in there and trying to leverage this in their system,
yeah.
You may not receive equity, and you have to be the one to look in the mirror and know what's right and wrong for you. The principles speak for themselves, and I'll just let it rest there, because we're not the moral police, but we do teach the principles. So this is not just a way to think you can get out of something or use the system. It's like Michael was saying, It's to settle your affairs in the system, exit, be left alone. Not to say you can't have credit or still operate or function, but you have to do it from a point of power, consciousness, and responsibility.
Yep.
And so that comes along with it. Any kind of power has responsibility. So I want to be clear about that, because it's not about rolling up and getting the new Cybertruck and making the dealer lose in the situation and tying up a title and causing harm in the system. It's not about that. It's about maintaining your autonomy and not injuring anybody in the process.
Being honorable.
Yes.
Amen.
Yeah.
Yeah.
Amen. Okay, real ending, fellas.
Yeah.
I'm sure there'll be some lingering questions, but we're going to dinner together tonight.
Yeah.
Thank you so much again, gentlemen. This was amazing.
Appreciate it.
Been incredible.
Blessings.
Thank you, brother.